items. Page number 1, item number 1, 2, 3. Page number 2, item 4 to 7. Plus item 7 will be taken up. Item 7 plus. Yes. The drugs disposal matter plus and file a complaint affidavit. That will take hardly 10 minutes plus. A possible fast item plus. A possible plus. A possible fast item. Today.
Let us see. First item may not be possible. Let us see. Upgrade the matter.
Case 3, item 8. Case 6, item 9. Case 7, item 10.
Item may be taken up today. It's a PIL regarding non-functioning of the RERA in a proper manner. I pray it may be taken up.
See. Okay.
Page 8, item 11, 12. Page 9, item 13 to 15.
Lord, item number 15 is a part of matter. Earlier it was posted to 2 p.m. on different occasions, but because of other engineering cases, those could not be taken up. Today also it was listed specifically at 2 p.m., but this honorable bench being not available, it has come at item number 15. So, my humble prayer, your lordship, to kindly take up this matter if possible today.
Just be there in 12. We'll try to accommodate you.
Page mention over.
I may be pardoned to mention that is WPC 33,000/2022. In spite of the direction of this honorable court to list it today on 31st of August, thrice it has been like this, my lord. It is not being listed, and I have to mention
tomorrow.
Lord,
it will come tomorrow.
Lord, this matter is relating to supply of Telugu books to Telugu speaking students. They are not supplied, they are facing difficulties. They are not
tomorrow.
Pardon to mention, Lord, in this case, was in shape of 12 years. Lord, the municipality, by breaking open the boundary wall of the PW department, Lords, encroaching the road mirrors, we are going to start 4 members of centers, Lord. And the road is being closed, Lords.
Road is encroached.
Well, they are broken the boundary wall, Lords.
File the petition. When have you filed the petition?
Well, petition filed yesterday, Lord.
So it will come next week. Yes.
My petition was dismissed on the ground. So I was not allowed to substitute a sole petitioner. There is the issue notice on the recovery.
We don't know. We'll examine whether it.
But the date was fixed to 25th of August. When the eviction matter may change.
Tomorrow. Let us see tomorrow.
I filed a CMA PL for the expression of the dismissed case.
It will come in there. No urgency, it will come in the next week.
I have mentioned several times. We will
it will come in the next week. Don't worry. Next week.
And another detectively there, the date was fixed to 12th May, but it was not listed yesterday. May I pray this to be taken up?
Next week. Next week it will come.
Another question matter, my lord. One company petition was disposed of in the direction to bring to the 3 months, but it was so much but I have found one hour, but it was not listed.
Before this court, relating to this court, the court doesn't take the contempt matter. So it will go to the assigned bench. Send before the listing or before the assigned bench.
I am pardon to mention, my lord. This DTPL has been filed challenging the order dated 29/8/2023 passed by the Honorable Single Judge, wherein a direction has been made to hold the President, Secretary and Treasurer of the Pani Panchayat, though in earlier petition it has been directed to inquire about 2 members, and those 2 members have declared invalid, and thereafter no election was held for those 2 members. Now the election, they are going to hold this election in this week for President, Secretary and Treasurer, my lord. By allowing those two persons, those who are declared invalid, they will cast the vote now, my lord.
Is it a division bench matter?
Yes, my lord, reappeal, my lord.
Retap.
Yes, my lord. Because without hearing me putting my order, that the fresh order has been passed, my lord. But by Friday, my lord, it will be infectious.
This tomorrow.
These matters relate to appointment under rehabilitation assistance scheme, my lord. Lord, similar such type of matters, my lord, is posted tomorrow, my lord. Writ appeal. My lord, let it be posted along with writ appeal number 810.
List to Mr.
Yes, my lord.
Kuntia. I mean, Mr. Kuntia is appearing, Mr.
Yes, my lord. My lord,
Rehabilitation matters.
I am for the opposite party. Yes. Yes.
You give a copy of this.
Yes, ma'am. Tomorrow may be listed.
The restoration matter, this was earlier mentioned before this honorable court. This matter was taken up by Honorable Justice A.K. Mahapatra, restoration application. But since he was concerned with the matter, he has recused and the matter was referred to your lordships for assignment.
You just mentioned before the deputy registered judicial.
We have mentioned earlier, your lordship, I had
Just as per the direction, I am mentioning today to place the matter before the appropriate order. Huh? This is not, we cannot pass any judicial order in such matter.
I may pardon. Fresh writ appeal. Contempt is filed any day next week.
Yes. Press submission item number 1.
Based on record, the note of dissent, which you are have filed it by various affidavits. And I also explained the source from where I obtained it. In view of the note of dissent,
Mr. Mishra, are you appearing for the list or no, Mr.
I have appeared to I am for the response.
Yes.
I want to file an objection to it. Before your lordship, I can show certain paragraphs of the writ appeal where it has been dealt in extensio by the honorable single judge. He called for the original records. Now, in 3 proceedings before your lordship, before the honorable single judge and one writ appeal filed by them, this document was never filed. And there is a categorical finding by the honorable single judge that no such document exists. Now, if your lordship will see this,
According to them, this document has been disclosed under Section 6 of the Right to Information Act.
no, that is what I want to point out. Even the petition filed by the appellant, his view was that he applied on the RTI and the document was not given to him.
So now maybe he has been.
Filed if your lordship permits me, I'll explain to your lordship on it. Before the process, there were other affected parties.
Yeah, yes, Mr. Palit. Yes. No,
I understand the bench only. What happened,
yes.
that should not have happened under Article 16. Public employment has happened in this case. I had, of the record, I had a personal occasion to produce that tabulation sheet and everything. Only thereafter, I had given an opinion that you scrap this whole thing. Everything was manipulated. Scrap this whole thing and go in for a fresh. Law Secretary endorsed my opinion. Thereafter, my lords, the records somehow mysteriously vanished. When I called for the records the second time, the records could not be produced. The records vanished. And then, my lords, the honorable single judge, I'm not getting into the merits now, my lords. Merits will be addressed to whatever, my lords, appropriate forum. The honorable single judge has been extremely kind. He will be kind now. This person has I know that he will be kind now. He's been extremely kind. My lords, he's gone out of his way. Everything has been brushed under the enters into a forensic examination of the my lords, affidavits filed and the call for the records. We produced the records and we said that some of the records are not there. They have vanished. Then, in that circumstance, the court gave certain observations. But with the rider, here, my lords, your lordship,
we give Mr. Mishra a short spend time for filing the objection, but it will be taken up on next Monday.
Yes, my lord.
No, not Monday, Wednesday, can I pray, my lord?
No, no, no.
No, what has happened in the meantime, my
It
lord?
is a parted matter, it is a marked part.
Yes. What has happened in the meantime, my lords? This portion here, also may kindly turn to page 115. Page 115. That part of the judgment.
Yes.
Accordingly, few lines from the bottom. Accordingly, this court directs the opposite party to immediately convene a meeting of the selection board in terms of Rule 7.2 of the rules. The names of the selected candidates which were uploaded in the website will be placed before the selection board. Thereafter, necessary action be taken by the opposite party number 1 pursuant to the decision of the selection board. And the Honorable Speaker within a period of 8 weeks from the date of communication of a copy of this judgment. Now, my lord, this is the punchline. It is further made clear that in the event, the selection board gives its concurrence to the list of candidates. My lord, the selection board called for the records. Kindly, your lordship, may read a copy. I'm just passing on the proceedings, copy of the proceedings. Good thing. One for the lordship, may kindly. This is the proceeding, my lords, based on which that order was passed. Having perused the judgment dated 19/5/2023 of the Honorable High Court of Orissa, so and so, and the available records of the selection process of the post of reporters for in pursuant to the advertisement dated so and so, the selection board observed as follows. The original mark sheet, tabulation sheets, the original answer papers of the written exam and the vivaros and other related records of the examination of reporters is not available. Under that circumstance, my lords, they were not in a position to approve it, so they cancelled it. And they were right, my lords. The Honorable Single Judge order only dealt with the first part, the preliminary part of the process. There's an examination committee, they will forward the names, thereafter, final approval is to be given on the 7.2 by the selection board. Selection board, after giving its recommendation and approval, thereafter it goes to the speaker for final sanction. But all that second part is not happened, only the first part. First part, and that is where the establishment or intermanipulation takes place, and the recommendation.
We'll continue in Monday.
I'm filing an affidavit, because what he is given today, subsequent to that, they pass the final order. Because the lordship in the last order indicated that what are the subsequent events that are given. I'm sorry, I don't have for Mr. Palit because I'm not there, but I'm giving to Mr. Mukherjee, my lord. I'm opposite party number 1. No, you are not going to copy. I bought no, I have one extra copy, I'll give. So, my lord, if you are anxiety, no anxiety, my lord. Why should that be addressing the Honorable Chief Justice? No anxiety. Kindly see page 4, my lord.
Yes.
Of what the letter was given to the pursuant that the final order is passed. But that is the subject matter of another petition. And if your lordship will see at page 5 and 6, they are giving the reasons. At the top, whereas the 3 members of the examination committee constituted by so and so 8 February submitted note of dissent. Now, he was the selection board, my lord, while considering my point, which I had sought for the order of the Honorable Single Judge, has again relied on that note of dissent. And further, if your lordship goes to page 6, he has stated, if your lordship will see the first paragraph,
Yes.
that they are saying that the original documents were not there and they have been cancelled and the fresh recruitment be conducted in a transparent and fair manner. The first paragraph in page 6, my lord. So, my lord, the very genesis of the order of the Honorable Single Judge, I'll point out just now, my lord, how they have manipulated. It's very surprising that a failed candidate, my lord, he cannot turn around and challenge the selection process once he takes part and given the judgment. Second, my lord,
That is obscene.
that the basis of which is challenging it, as your lordship pointed out last time, a person belonging to a different category cannot challenge the appointment of a person belonging to another category. That judgment that placed I placed on the last day before the lordship.
Here is a problem.
But yes, the lordship has been pointed out to me.
Placed before us.
Yes,
That also says how the entire process has been cancelled.
Yes, my lord, I wanted to use the lordship to page 97.
Yes.
Kindly see page 97 of the writ appeal filed. There, if your lordship will permit me one paragraph I read out,
Just read
that
it.
will counter whatever they are saying. Let me be permitted, my lord, if you are honorable single judge could have as well granted a mandamus, given the appointment. Yes, my lord, what the single judge has, there is a dispute. My lord, what the honorable single judge held, that the writ petition they took up in their counting my application, that it is premature because the selection process is not complete. Because under Rule 70 of the Legislative Assembly rules, the selection board, after the select list is uploaded, they have to take a final call and pass an order. So the single judge, relying upon D.S. Kashyap, 3-judge bench of the apex court which held, with the right, I cannot claim any right, mandamus cannot be issued. But the corresponding rulings upon the government to say if the selection process is fair and there are vacancies, they cannot arbitrarily cancel the selection process on the argument of Article 14. So relying on that judgment,
All right.
wants to argue. And his client's father is working there. That is the knowledge. If a person has to personal allegation has to be made point. The person has to be made a fact party. Saying that this person is part of the selection.
Are you going to hear it today or on Monday?
I'm sorry, Monday. I'll file my objection to this matter.
Is the habit of putting in the last word.
No, my lord, I have invested.
Appear for both respondents number 2 and 3. In the meanwhile, the respondents number 2 and 3 may file their response in respect of the affidavit filed by the appellant, placing the note of dissent dated 29/8/2021, which according to the appellant has been disclosed under Section 6 of the Right to Information Act. So, Mr. P. Mukherjee, the senior counsel, is stated by Mr.
SD Rai. SD Rai.
S.D. Jal and counsel has appeared for the appellant. And Mr. Senior counsel is stated by
A. Pradhan, Miss A. Pradhan.
Ms. Pradhan appears for the opposite party number 1. And Mr. Subrat.
Document take my minutes into on the record.
All right.
I have filed the minutes and my affidavit also, my lord, today.
Yes, sir.
Bringing the subsequent events in record.
Yes. Mr. Khalid and his senior counsel has submitted the minutes of the meeting of the selection board held on 15/7/2023. The same is taken on record. The affidavits filed by the appellant and the other affidavit filed by the respondents number 2 and 3 are also taken on record. Great.
Your lordship has.
Monday.
Item number 3. Yeah, please, Your Lordship.
Yes, Mr. Paul.
My lords, there's a writ appeal challenging the impugned order at Annexure 5. The issue was, my lord, before the learned single judge, regarding applicability of the ESI Act and the EPF Act to the casual workers of the university. Now, the first submission was before the single judge that I, being a state university under a statute, I am exempted under 16 of the APF Act not to register myself. Now, that aspect was never considered. Even the judgment 2007 Supreme Court was cited. It has not been considered. And straight away, on the basis of the notices given to me by the authorities, they simply said, since they have given these notices, it is applicable to you. Now, kindly come to, my lords,
You have challenged that notices also.
No, I was the petitioner, I was the opposite party there.
Okay.
Petitioner is the respondent number 1, that is the union.
They want the benefit of the
applicability,
EPF,
EPF and ESI,
both together.
both together. My difficulty was, I also pointed out before the single judge that EPF you have assignment, but ESI you do not have. That was also not taken care of. Well, it's, ESI assignment was with Justice Arindam Sinha. So that also, there is a defect in this judgment. So, my lords, before I proceed, I will just want to point out the EPF Act. Or rather, I'll point out, my lords, the judgment I have cited at 216. This AI 2007 Supreme Court 276.
Yes.
Here, my lord, the EPF commissioner had filed this civil appeal, wherein a non-government education institution which was aided by the government under a statute of Rajasthan. Now, your lordship will kindly come to page 219, para 14. Your lordship got that?
Just a minute.
My lord. Para 14, my lords. 219. Internal page 4 of the judgment. Now, the issues, the question was framed by the Supreme Court. Being agreed by this order of the High Court of Rajasthan, the appellant RPFC has approached this court. As we understand, the issue before this court is whether the provisions of EPF Act 1952 are applicable to the non-governmental education institution or not in view of the provisions contained in section 16 of the EPF Act. So, answering this question, my lords, your lordship will come to the next page, para 19.
Yes. Both the question answered in para 19.
No, subsequently it has been answered. Para 19.
Yes.
These submissions made. It was submitted by the Learned Counsel that the Learned Single Judge and Union Bench of the Rajasthan High Court have not correctly appreciated and interpreted section 16(1)(b) and have wrongly recorded that all education institutions are under the control of the state government as they are recognized by the State Act of 1989. He pointed out these education institutions were running and are managed by registered societies and none of them are owned or managed by the state government. Merely on the basis of recognition of the state government, State Act of 1989, it could not have been held. These educational institutions are under the control of the state government as required under section 16(1)(b) of the EPF Act. I pointed out this because in my case, it's a totally state-owned, governed institution, university. Now, answering this in the negative.
What is your institution?
I'm a state act, under a state act of 1962.
It is for purpose of affiliation.
No. I am a state constituted under by the act of assembly.
Okay.
I've given the state act also.
All right. You are an university.
I am a state university constituted under an act of 1962.
All right.
The governor is the chancellor. Vice chancellor is appointed by the governor. All other functionaries at the board of management are ex officio government employees, posts. And entire fund is by the state government and the central government and the ICAR, the Indian Council of Agriculture Research.
So according to you, section 16(1)(b) applies.
Applies and I am exempted.
Okay.
Now, so far as the regular employees are concerned, I have a contributory provident fund. Now, because I have a contributory provident fund and it is not applicable to the casual employee, they say that the EPF Act applicable. But the 16(1) says that it is that I am exempted once I am on the state or central government governed. So that has not been taken care of at all by this honorable single judge.
Let the relevant part of the
Yes,
judgment. Annexure 5.
Annexure 5, my lords, if your lordship will take up 213, page 21 of the judgment, para 10. Your lordship got that? Yes.
Institution not under the control of the government.
May I place that one?
Yes.
Having heard learned counsel for the parties and after going through the materials available in record, it is found that the petitioner representing the casual laborers working under OEAT is before this court with a prayer to direct the opposite partner 2 and 3 to extend the benefit of EPF and PF Act as well as ESI Act in favor of the such casual employees. As found from the communications available from Annexure 2 to 17, well, these are communications by authorities. It is quite apparent that the casual employees working under OET are liable for their coverage under provisions of the EPF and PF Act as well as the ESI Act. It is also found from the record that opposite 2 and 3 by communication issued under Annexure 13, though decided to cover the casual employees under the ESI and EPF Act, but no final decision was taken in that regard. Well, there is no estoppel in law. It is also found from Annexure 14 and 15 that the casual employees working under the OET are liable for their coverage under the provisions of EPF and ESI Act. The stand taken by the university taking recourse to the provisions containing section 16B of the Act is not applicable as the casual are not getting the benefit of contributory provision for old age pension rule. Even though it is admitted in the further affidavit so filed by the OET that the employees of the university are covered under the provisions of CPF and old paid pension, but no specific evidence made therein that such benefits is also extended to casual employees to which the petitioner union represents. It is also found from the record that Appeal 4 and 5 time and again though have issued directions to the university to register the workmen under the provisions of EPF and ESI Act, but the university all through of the phase of Annexure 13 order is not taking
your contention, sole contention, that you are exempted.
Under the EPF Act. I'm exempted. Second is ESI. Said there is a provision under section 75. The ESI court has to decide whether a particular organization is required to register with the ESI authorities so far as their workmen are concerned. The ESI code is the decision ownership. That was also submitted before the section 75 was placed before the Honorable Single Judge, but they have not dealt with. So once there is a provision under the Act, your Lordship knows that once a provision is there and an act is to be done as per that provision, there was no question of judicial review under 226 or 227.
So there are exceptions also.
Yes, there are, definitely. If, my lords, there is a provision that section 75, then there is an other appeal provision is there.
Is referring to the writ petition of Mr. Pangari?
Yes, yes.
Let him complete. I think
completed. This is the two contention. He says the two. One is that under the EPF Act, because of section 16(1)(b), the university is exempted from the EPF provision. And separately, there is in the ESI Act, there is a provision. If you are deprived of, you have to go to the designate court. And for the present purpose, designate court is the district judge court. I think you are referring to this for. Yes, says that so proceeding under 226 is not maintainable. This is the principle.
Let me say these two are the only submissions he has to make, then I'll answer.
No, I am pointing out. He has not pointed out. This is the only submission.
So let me complete.
All right. Anything more, Mr.
Who has anything else? So that
I think these are the two major grounds.
Yes, ma'am.
Okay.
Yes, ma'am.
In this matter, I am already appeared on behalf of the provision for Nation Millet. I filed Bhaktatna today Millet.
All right. What is your stand?
Yes, my friend is not correct. The university has already covered by virtue of the notification number. Notification 986 on 19/2/1982. All industry was covered, and in this case, this case, already they have applied the act to some establishments. Others they are not applying. They have already applied 2 projects. Rest they are not applying. Specifically, as my stand was in the counter that once you have applied the act to the 2 projects.
Oh, just you have to clarify that. University is one entity, and projects under the university can be the different entity also.
Yes, the university, it is not covered under the act. The university employees, the regular employees, they are getting their salaries from the university, But regarding casual employees, that is 0-day coverage. 0-day coverage means any employee who work for a day, he will become a member, and the provisions of the act will apply to that person. And casual employees, they are not covered under any other organization. Section 16 says that if any employee is under the provisions, you can see the section 16 and pressing it.
All right.
Section 16 is not applicable because you are seeing the section 16 years.
Yes.
The act not to apply to certain establishments. This act shall not apply to any establishment registered under Cooperative Societies Act or under, this is not applicable. Then that's B. To any other establishment belonging to or under the control of the central government or state government and whose employees are entitled to the benefits of contributory provident fund or old age pension in accordance with the any scheme or rule framed by the central government or by the state government. This is not applicable. So once this scheme is not applicable, they are not the employees, they are not coverable, they are not getting benefits under any contributory provident fund or only pension funds. They are covered by the effect statute. Or that is in government statute, the government specifically.
Where is your notification?
It is there. It might not be your university book. I am giving it.
Oh, you are not with us.
University might not be in your university book.
They are quoted in the judgment.
It's been quoted in the judgment.
Let's go back to judgment. Paragraph 4.2. The Government of India notification, 82 notification that holds the field today, my lords, covering universities, any university, any college.
That notification number दिया
So the notification that no dispute. They say yes, we are covered, but we are exempt paid under 16B. And satisfy that where court has dealt with, and the manner court has dealt with. My friend misled it there. Directly going to paragraph 10. The last portion of the judgment, but paragraph 4.3.6c. Elaborately, the court has dealt with this particular submission 16B whether it is applicable. So 4.3 of the judgment, Lord.
Sanatan Government is not applicable. It's just
We'll come to that. It is distinguishable. So,
All right.
also can see paragraph 4.3. Yes. Ask my friend to say what the court has dealt with this submission that 16B. You are exempted under 16B. Paragraph 4.3 of the judgment, Lord. See. Page 13. That's you got it now?
Yes.
It is also contended that as per the provisions contained under section 16B of the EPF and MP Act, the provisions which say that shall not apply to any other establishment belonging to or under the control of the central government or a state government and whose employees are entitled to the benefit of contributed fund, old age pension, in accordance with any scheme or a rule framed by the central government or the state government governing such benefit. It's contended that since the workmen working under the EAP are neither entitled to the benefit of contributed provident fund or old age pension scheme, the bar content of section 16B of the Act is not applicable to the claim of the workmen. I'll take a pause, my lords. Section 16B, to get benefit under section 16B, a twin test has been tested by the courts throughout. What is the twin test? First, it's a government establishment. They satisfied. Next, all our employees, workmen must be covered under some scheme, some pension scheme.
Some those are left out, they will be covered by the IP.
Minutes. So unless some establishment satisfy these twin test,
Yes.
they cannot claim exemption. Because otherwise, under the notification, they are liable to be registered. They are covered under the notification, under the Act.
Yes.
But they claim exemption. And one condition they can claim exemption is this satisfying these twin tests. So as Sanatan once as that case is concerned, they satisfy these twin tests.
That is there in the judgment. My friend should have taken lordship para 33 of the judgment, where the court has said, yes, they are a government controlled institution. Also, they have governed their employees under the scheme. In the place of a scheme, some other scheme. So here lordship see, para now, para 4. How we have answered, or court has answered, para 4/4. Mr. A. Kodal on a senior counsel in support of the submission. Either the claim made under the writ petition relied on the decision of the Honorable Apex Court in the case of Pawan House Limited and others versus Aviation Commercial Sangathan and others. CBD appeal number so and so. This is latest on this subject. Honorable Apex Court in para 6 of this judgment has held as under discussion and analysis. It is first required to be seen whether appellant company is excluded from the applicability of the provisions of the EPF Act and the EPF scheme framed thereunder as contemplated by them. As per section 1(3) of the EPF Act is applicable to every establishment in which 20 or more persons are employed, which is either a factory engaged in an industry specified in Schedule 1 or an establishment which the central government may by notification in the official gazette specified in that via. Section 1(3) of the EPF Act reads as follows. Then let's see section 16 at the bottom. 16(1). Act not to apply to certain establishment. This act shall not apply to any establishment registered under the Cooperative Society Act. We are not concerned. To any other establishment belonging to under the control of the central government or a state government and whose employees are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefits. So here the twin test is put in B, 1(3)B. First, it has to be government establishment. They must have some scheme taking care of the workers under some provident fund, contributory provident fund, old age pension. Some benefit has to be there. So here they felt admittedly, as my friend has filed a document saying that we have a contributory provident fund scheme. But that scheme itself, let's see, I'll complete this judgment because this will be a ridiculous judgment. It will be fair, my lord. So let's see. 2. If the central government is of the opinion that having regard to the financial position of any class of establishment or other circumstances of the case, it's necessary or expecting to do so, it may by notification in the official gazette and subject to such conditions as may be specified in the notification, exempt whether prospectively or retrospectively that class of establishment from the operation of this act for such period as may be specified in notification. This court in Provident Fund Commission versus Sanandan Dhan Girls Secondary School, that judgment my friend of free. Secondary school, laid down a twin test for an establishment to seek exemption from the provisions of EPF Act 1952. The twin conditions are, first, the establishment must either belonging to or under the control of the central or state government. The phrase belonging to would signify ownership of the government, whereas the phrase under the control would imply superintendence, management, or authority to direct or restore or regulate. Second, the employees of such an establishment should be entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or state government to governing such benefits. If both tests are satisfied, an establishment can claim exemption exclusion under section 61(b) of the EPF Act. Applying the first test to the instant case, the central government has a 51% ownership in the appellant company who is the balance. This is about Pawan House. And 49% is owned by ONGC, central government PSU. As per section 2.45 of the Companies Act, the government company means a company which is not less than 15% of the paid up share capital is held by the central government.
Issues.
So it's not disputed that this is a central government, state government controlled university. With respect to the second test, it's relevant to note the company had its own scheme, the Pawan House Employees Provident Fund Trust Regulation in force. The company, however, restricted the application of the PF trust regulations to only regular employees. The PF trust regulations of the company were not framed by the central or state government, nor are they applicable to all the employees of the company so as to satisfy the second test. Here, the scheme they have introduced clearly excludes
the casual employees.
Casual employees, or civilian employees, or contractual employees. So they have not passed the twin test. Then, in this judgment, approximately 300 to 400 employees have been engaged by the Power House Limited on contract basis in various cadres, but no social security benefit is being extended to them. The EPF MP Act under Section 2F lays down that any person employed for wages in any kind of work, in or in connection with the work of the establishment, and includes a worker engaged by it through a contractor. There is no distinction between a person employed on a permanent, temporary, contractual, or casual basis under Section 2F of the Act. You are therefore requested to implement the provision of the EPF Act in respect of all this. This is the letter issued to Power House. In view of the company doesn't satisfy the second test, since the members of the respondent union and other similarly situated contractual workers who are not getting the benefits of contributory provident fund under the PF trust regulations framed by the company or under any scheme or any rule framed by the central government or state government. Consequently, the exemption under Section 16B of the EPF Act would not be applicable to the appellate company. In view of the above discussion, we hold that the company has failed to make out a case of exclusion from the applicability of the provisions of the EPF Act. The next issue which arises for consideration is whether members of the respondent tribunal are entitled to the benefit provision fund regulation under the EPF Act. Then they proceed and they give the finding 6.4. We find that the members of the respondent union have been in continuous employment with the company for a long period of time. They have been receiving wages, salary directly from the company without informing the contractor, so on, so on, so. In our custody, clause 2.5 of the PF regulation would be undoubtedly covered all contractual employees who have been engaged by the company and draw their wages, salary, so on, so on, so on. Then they go to 2F, employee definition, which covers all employees. In view of the above discussion, we find that the members of the respondent union and all other similarly situated contractual employees are entitled to the benefit of provident fund under PF trust regulations or the EPF Act. Since the PF trust regulations are in force and applicable to all employees of the company, it would be preferable to direct that the members of the respondent union and other similarly situated contractual employees are granted the benefit of provident fund under the PF trust regulation of the service conditions of all the employees of the company. So, court extensive has relied on this judgment. This is which has also dealt with Pawan House judgment. Pawan House judgment also has taken note of the twin test in Sanatan Sasta case.
That is also there.
No, that's and the verse is Sanatan Sasta judgment, which my friend signs. That judgment itself. No, so it's page 219.
Both the judgment has been raised before the learned single judge. Both the judgment has been examined by the learned single judge.
But still, Sanatan Sasta case, since my friend has cited, the judgment itself distinguishes from Pawan House case and the other case. Para 33, let's see. Para 33. Page 2 to 5. Para 32 is the first test. Para 30, first state, that is controlled under the state government. Para 33, in our view, the State Act is a complete code in itself with regard to the education institutions, and the state government exercises substantive control over the institutions even though so. This is para first part. However, in this court, notification of the government. No, notification of the government. Yeah, we are the twin test.
You come to this, this is in next to the paragraph where it discusses about the section 16 in the judgment. It is in the para 6. Para 6, the pages are not.
No.
The judgment you have referred. Page 9 of their judgment. There is a page 9. 9 you will find it just at the bottom of the page. It is the printer's page, not the judgment page.
Yes, sir.
It's just at top. The twin conditions are. This guy.
This has been quoted. But this honorable signature. This has been quoted that
Now, what is the distinction? They have approved this test.
Yeah.
In Pawan House also they have approved this test. Pawan Halls also the twin test has been approved.
No, in Pawan Halls they say,
This is Pawan Halls.
no, it's not approved. In Pawan, it's not approved. Lordship, judgment.
Yes, just come to this.
Lordship, see at the end.
Yes, they are saying this in next, this the same place, come to the line at the bottom.
No, my lords. Where they say the relevant extent of the letter of the commissioner, in our view, the company doesn't satisfy the second test. She is the members of.
So they are applying the twin test.
Yes. Yes.
In Pawan Halls also the Supreme Court is applying the twin test.
So I'm saying.
Second test has not been confirmed.
So exemption is not applicable. That's what they said. The respondent union and other senior citizen contract workers who are not getting benefit of contributed provident fund.
Yes.
Under PF trust regulation framed by the company or under any scheme or any rule framed by the central government or the state government, consequence of the exemption under section 16 of PF would not be applicable to the applicant company. So same position here. It may be a state government control organization. They may be satisfying the first test. But Lordship now see this scheme they are referring to. Admittedly, my friend has said that this scheme is not applicable to the seasonal or contractual employees. Page 134, Lordship see. Page 134.
This is a part of affidavit.
Yeah, this is my friend's petition
for the
appeal, 134. This is statute. The statutes when we call the Orissa University Agricultural Technology Employees Statute. They shall apply to officers other than the Vice Chancellor, teachers, and other employees of the university. Then let's see other employees. The employees they have defined. There's 150, let's see.
157 first.
That will go to that. We'll go to that. 150.
150.
Manner. Pension or contributory provident fund. Every employee who has retired on or after so-and-so date, they entitled either to the benefit of the pension scheme as applicable to the state government employee as amount for time, or to the benefits of contributory provident fund to the university contained in chapter so-and-so. Provided, however, that for the purpose of contributory provident fund, the term employee shall be as defined in chapter 7 of these statutes. 157, Lordship, they have defined.
Yes.
157, page 52. Employee means a person employed by the university as a full-time employee and includes the officers and teachers of the university, but doesn't include a part-time employee of the university or a government servant on deputation to the university.
Yes.
So here they exclude. That's what the Pavana's case has done. That yes, you have introduced a scheme, but doesn't cover all your employees. In our case, it's more than 200. Some of them are dead after having worked 15 to 25 years, 30 years. Some of them are dead.
This is a part of the notification. The page 157.
Yes, it's a statute by the after the. This is the statute of the university.
It's a statute.
Yes. So under this, they give it to contributory provident fund to the usual employees only and exclude consciously all others.
The statute is at page 102. The Act. The Orissa University Agriculture and Technology Act 1965. That is 102.
So, brief facts. Another misleading statement that was made, that all authorities demanded that it should be given to the employees. And court has relied on that. There are 5 documents in that university. When workers raised the demand, it went for conciliation. Before the conciliation officer, they said, take out Annex 3. They said, we are implementing within a month's time. Then government of Orissa, administrative having control, also wrote to them repeatedly that you must comply with these provisions of EPHES Act. In first 2 pages of the judgment, Lord Singlage has referred to each and every annexure, where government of Orissa 3-4 times has said you comply and report compliance. They didn't do. We came here not to raise a dispute. That is not applicable or whether it should be applicable. Which would have taken us to go for recourse on the EPF Act or Section 75 of the SA Act.
All right.
So we can have for implementation that you have decided to give it. And let's see, 2-3 documents I show. The Vice Chancellor is registered in writing all the things that he gave it to them. Page 46 will actually see that the appeal. And this is page 46. It's not that the authorities have written letters and Honorable Singlish has relied on those letters. They themselves have written to the register. As per our demand, the authority wrote to them. Annexure 2, page 45, the ESI corporation wrote to them. Then under annexure, page 46, annexure 3, the EPF commissioner wrote to them. Then Lordship's annexure 4.
Yes.
I'm sorry, this is in Odia. Annexure 4, the Vice Chancellor is writing to all their project heads and the teams that they implement. Then Government of Orissa, Minister of Labour and Employment Department, Annexure 5, writes a letter to register that you implement the Provisions Act. Then page 46, page 49.
Yes.
The register writing all deans, directors, dean colleges, agriculture, all their establishment to furnish name and number of casual laborers working on the establishment for the purpose of this scheme.
All right. Total number still 185.
So
185. These are casual workers.
Just right. Number will be actual more than 200.
No, you have said
one submission made to none of the authorities. They have ever written a letter that the scheme of the act is not applicable to us. Only you make petition for the first time. Those are authoritative actually to determine a matter. They have never raised. They always say we are directing our people to do. In fact, to 2 of their units, they have already implemented.
Yeah, there is no estoppel in law. So, question is not whether has referred to.
That's all right.
Yes.
You said I was dispute to High Court for the first time. For that I'm saying, not because we stopped it. You are very justified to have raised the issue here. Question is not that. Question is the conduct of an university. A statutory university, public university.
Yes, that is the exact point. The statutory university is a public university, state government, central government. All funds are given also in the affidavit. Entire fund of around 500 crores is given by the state and central government. So I, first of all, first twin test, I satisfied so far the twin test.
No, he's not opposing that. The first twin test you satisfy. Because you are the central university or the state university. So you are covered by the definition university and you cannot directly come. But question is the left out casual employees. They are not covered by any of your schemes.
The difficulty here is that the statute, our statute says, defines the employees. Now, 16(1)(b), twin test I satisfy, I have a contributory provident fund. I have exempted or taken out these casual employees from the scope of contributory provident fund. The difficulty is that they are governed by the central government fund under the ICR for different projects. They do not work directly under me. They are projects works which the central government funds, the Indian Council of Agriculture Research. Now, since it is entirely funded by the central government also, it will not be applicable to them.
But this part is not, anybody is questioning this part. Only this, what about as an institution, this judgment, 2 judgments, they have clearly laid down that those who are left out of any of this.
Our one says about left out.
Yes.
Bhavanand says our left out.
Yes.
Now, so far as EPF is concerned,
They are not honest. Which is there.
the first of all, the provision under section 1(3), you also will kindly examine this aspect. After the twin test, 1(3)(b) comes in. Subject to the provisions contained in section 16.
Yes. You are reading from?
Well, the EPF Act.
Section 1(3)(b).
Section, I am asking you the section 3.
1(3)(b).
1(3)(b).
1(3) first, subject to the provisions contained in section 16. It applies to any other establishment employing 20 or more persons or class of such establishments which the central government may, by notification in the official gazette, specify in this behalf. My lord, it is a delegated power given to the central government. Now, the kindly read the proviso, my lords. Provided that the central government may, after giving not less than 2 months notice of its intention to do so to do by notification in the official gazette, apply the provisions of this act to any establishment employing such number of persons less than 20 as may be specified in the notification. No such notice has been given to me.
Their stand is 1682 is not applicable to them because there you know.
It's my language does not allow me to.
Right.
So my submission is the proviso is a qualification for giving a notification. So the 2 months notice, it establishment 2 months months notice. Establishment, any establishment, so specific. There has to be a 2 months notice to me. They said the central government saying that you are to be under now covered. These casual employees, all employees has to be covered. EPF Act will be applicable to you. No such notice was given by the central government. Only the EPF commissioner writes to me. They do not have any authority. On the basis of those letters of implication of the EPF Act to me, this honorable single judge has concluded that yes, this EPF Act is applicable to the other who have been left out by the statute. So my submission is this after section 16 twin test, 1(3) also has to be read with section 16(1)(b).
I reply to this one.
I'm sorry. Nobody's right. I know honorable chief justice is very patient.
Yes, shall I interrupt for a minute? Just a minute. My friend has annexed all documents except my counter filed before the honorable single judge.
It is not.
My friend has not enclosed the counter filed by me.
Okay.
In that specifically, the record is there, Millard. So you can also there is specifically all these things are not necessary because
in data appeal I'm not supposed to. And you have given the record is there.
But you must apply or you must enclose all documents. You are suppressing that. On that score, you are liable for dismissed.
In the data appeal I'm supposed to only impugn.
Specifically, I have stated that that it is only submitted that earlier this opposite party had made a number of correspondences with Registrar of AOT and Government of Odisha, Labour and ESI Department, or other things regarding the coverage of AOT workmen and on constant follow of Government of Odisha Department of Agriculture and Farmers Empowerment by letter number such and such to allow EPF benefits for AOT workmen. Accordingly, 2 units under AOT, namely Dean of Research and Mrs. Director of Physical Plant, have already been covered online under EPF website with PF code number such and such, respectively. Out of the 2 establishments, Mr. Director of Physical Plant, Bhubaneswar, has deposited PF and allied dues in respect of its employees up to the month of 8, 2021. So once you apply the provisions of the statute to your establishment, casual employees for 2 units, you are bound to apply all others. For that, for this reason also, my friend has not enforced my copy of my counter.
No, that is
In that I have another document which clearly says that they have that this is the letter of the government needed.
Yes.
This is the copy I have annexed to as annexed C by 5. The government of Odisha Department of Agriculture and Farmers Empowerment, which is the administrative control of the investments. The implementation of the orders is done on such and such. In inviting a reference to your letter of such and such on the subject cited above, I am directed to say that government have been pleased to approve applicability of the provisions of the Employees State Insurance ESI Act such and Employees Provident Act EPF of MP Act 1952 to the casual laborers engaged in different projects of PUT. It is therefore requested to kindly take any action at your level for implementation of these above schemes to the casual laborers engaged in different projects of PUT under intimation to this department. The government has written this register. So while all these things are there, I don't know how the investor is not interested to give the members to apply these provisions of the act to the casual laborers.
Yes.
Unfortunate.
My lord, so far as ESI is concerned,
Yes.
first is that regarding their assignment. And second, my lord, section
SI
7.
cannot be the ground, even if
I just wanted to point out, I am not pressing that.
Just I'm telling you, just we will not take it further, that when the jurisdictions collate or overlap each other, jurisdiction can be.
My lords, I am not pressing, just pointing out.
Yes.
Section 75 1G matters to be decided by the Employees Insurance Court, ESI court. So that is the district judge. So there any 1G says any other matter which is in dispute between a principal employer and the corporation or between a principal employer and an immediate employer or between a person and a corporation or between an employer, a principal or immediate employer in respect of any contribution or benefit or other dues payable or recoverable under this act or any other matter required to be or which may be decided by the Employees Insurance Code under this act. So it directly falls under section 75. So exercise of power under section 226. Judicial review should have been little because there is a forum.
Just I am asking.
There is a forum. There is appellate forum.
All right, but I am asking you one question: that when statute provides in some way, and Supreme Court interprets the very statute and makes the casual employees entitled to get the benefit under the EPF Act, and you are not granting it, cannot be. It is the subject matter of the judicial review.
No. I'm not talking about EPF. I'm talking about ESI.
No, ESI, we are not very concerned. ESI, I don't think you are pressing now.
No, ESI, there already government has issued a notification making that.
No, because I think whether can you get the dual benefits?
No, ESI is different. ESI is different, EPF is different. So both the benefits they'll get.
All right.
Both the benefits they'll get out of that.
ESI to give these several services, not the
services. They'll get. My friend is saying it's not adjudication under ESI Act could not have been made under section 75. What should kindly say 75? Where is the dispute? You have already implemented.
No, he is raising the question of jurisdiction. The jurisdiction is provided to the district judge. Why the dispute should be brought under Article 226?
No dispute was brought under Article 226.
Yes.
75 is specific. What are the matters to be decided by the district judge? It's there. Our matter is not that.
Okay.
Our matter is non-implementation. You have decided, you have committed, government has decided. Also, we see what are matters to be decided by ESI court.
That is the
71G.
It's not there.
It's there. 71G.
Any matter which is in dispute between the principal employer and the corporation. Please note. Principal employer and the corporation. Or between the principal employer and an immediate employer, or between a person and the corporation, or between an employee and a principal or immediate employer in respect of any contribution, after cover, or benefit or matter required to be or
other dues payable.
Please. Payable. So
other dues payable or recoverable.
We are on coverage.
So unless I'm covered, how will I?
Exactly.
So deciding, adjudicating authority is the ESI court.
The government has decided it has.
Any communication with the EPF or ESI authority with me or the state governments does not make the law.
No, it's not law, it's all right, but there is a decision.
No, ultimately, on basing upon my opinion, they decided to challenge it, basically oppose it, that we are not covered. And thereafter, a stand was taken, because initially this writ was allowed on the first date, it came in writ appeal, it was remanded back. Then it was decided on merit. So these aspects has to be dealt with and tested. Your Lordship, test this on this basis. 17(1)G, 75(1)G, so far as the ESI court is concerned, because there is also an appellate forum before the FA, before this court.
All right.
Then regarding 75, I think the Lord is, our answer is clear because 75 doesn't cover our issue.
You also place the matter differently. You says there is no controversy, state government has already directed.
State government has directed that themselves have also implemented.
Adopted, yes,
Themselves have implemented. So this dispute, the question is normally under 75, workers have never gone. I have never seen a case. The management have gone. It's for them to go. And the benefits, specific services provided by the ESI Act, quantum of deposit,
yes,
how much to be deposited in a month, all that will be covered. Not this. It's not that dispute. Suppose the authorities have imposed that yes, you have to deposit this the dispute, then they go. Or suppose workers say the deposit 20 rupees in a month, workers say no, your contribution should be 30 rupees. In those cases are different. Here it's not that, not a single dispute here under 75. It's a principle.
all right.
Then so far 1.3b is concerned, no, 1.3 is not. My friend has missed this. Notification 1.382, he says not applicable because that specific establishment has to be notified. No. Language is establishment or class of establishments. No. So all universities in the country.
No, 1.3b is not applicable. 1.3b says below. 1.3b says it is less than 20. Yes, notice is there for establishment because once 20 is there, then 20 or more automatically it will be covered. It is due to the employer to be covered. But section 1.3b, you can see 1.3b that says specifically it is less than 20. 1.3b, my friend has misled. 1.3b
Right.
provided central government that provision minutes provided that central government may, after giving not less than 2 months notice of its intention so to do, by notification in the official gazette, apply the provisions of this act to any establishment employing such number of persons less than 20 as may be specified in the notification. And in the present case, notification I have already pointed lordships to that the industries, all industries were covered with effect from 982. That is 82. This from the year 1982. That is
Reserving the order. The Lordship is reserving the order.
No, I dictate the judgment right.
My Lordship.
all the industries were covered with effect from 19 February 1982 by resto number 986 dated 19 February 1982. So all industries are covered. And in this case particularly you have applied. You yourself covered. And you have applied to your units. The rest you have to apply. So this question's application is not necessary at all. The application is done on section 1.3b. So under section 1.3 it is applicable. Then the question contempt. But assessment of contempt. So for assessment of contempt, the ones 2 units you have covered, the rest you have covered. And especially the additional department categorically stated exactly the matter stated that the provisions are applicable to industry for casual employees. We are not concerned for regular employees. We are concerned with the casual employees.
Yes, that is the.
Yes, so once the government has decided that all the units should be covered in respect to casual employees, you have to cover. Person nothing more than that.
One line, page 17 verse. Page 17 of the appeal. I'm sorry.
Page 70 of the appeal.
1 second. Appeal memo. But the ground F of my friends. I don't know how much will deal with this. I strongly disapprove this. I wanted this to be come to the notice of the court. Because this particular word, I checked the dictionary meaning, I couldn't accept it. Meaning of this word is going crazy, going berserk, going mad, going deranged.
17 or 70?
17.
The main appeal.
The Honorable Single Judge, while exercising the power of judicial review, has gone berserk, and while doing so, has wrongly, illegally changed the service condition of the casual workers. This word berserk, I checked up the dictionary. It means going crazy, going mad, going hyper, going deranged.
Going scattered way. There is not a disciplined approach to the thing. Do you know one thing, Mr. Pangari? Now, everywhere in computer, you'll find there is a species of English language, Indian English.
Yes.
So you don't go to the Oxford or Cambridge to find out the meaning of the Indian English. Heard Mr. Avijit Pal on counsel appearing to the appellant. And also Mr. L. Pangari, our senior counsel, is stated by Sohan Mr.
Yes, sir.
And counsel for the respondent number 1. Answer your name. Last time you were not there. And Mr. S.S. Mohanty, learned counsel, appearing for the
Respondent 4.
the respondent number 4. Why 4? I think 3 also you represent. No. This is a ESI.
The 3 is registered. 3 is ESI. They have not appeared. Huh? Only EPF has appeared.
Always appears for the opposite party number 4. And Mr. Khuntia, or who is appearing for the state in this matter?
State is a
Party, but you have not appeared.
not pro forma. It means they are necessary.
Always. None appears for the remaining respondents.
Then only provide funds. Then at a party.
By means of this intercourt appeal, the judgment dated 27th June 2023 passed by the learned single judge in WPC number 19688 of 2021 has been challenged. Learned single judge by the said judgment has observed inter alia that But it is found from the communication available under Annex 2 to 17 to the writ petition that the casual employees working under Orissa University for Agriculture and Technology, or UAT in short, are liable to be covered under the provisions of EPF, provisions of the Employees Provident Funds and Miscellaneous Provisions Act 1962, in short, EPF and PF Act, and also under Employees States Insurance Act 1948, in short, ESI Act. It has been observed with the learned single judge that the record produced by the opposite parties number 2 and 3 in the writ proceeding, it is evident, particularly and also from the communication under Annex 30 to the writ petition, that it has been decided to cover the casual employees under the ESI and EPF scheme, but no final decision was taken in this regard. So, the stand taken by the university that it is exempted under section 16 of the bracket 1 within the small b of the Act, and hence the casual employees are not entitled to get any benefit under APF and MPF stuff. When a single judge has observed that it is an admitted position that the employees of the OUAT, regular employees of the OUAT, are covered under the provisions of Contributory Provident Fund and the Old Age Pension Rules. Stop. According to the learned single judge, OUAT has avoided any specific government whether such benefit is being extended to the casual employees. Stop. But the petitioner, the Union of the Casual Employees, has categorically contended that no benefit relating to Provident Fund or the insurance under the ESI Act are being extended to those categories of employees who are working under OUAT. Stop. Having recorded this prospective fact and discussing the relevant provisions and the decision of the apex court, learned single judge has directed opposite parties number 2 and 3 in particular to extend the benefit of EPF and ESI in favor of the casual workers, employees working in the OUAT within a period of 3 months from the date of the receipt of that order. In this intercourt appeal, the said opposite parties number 2 and 3 are the appellants who projected the challenge against the said judgment of the learned single judge. Mr. Paul and counsel appearing for the appellants has straightaway submitted that Section 16(1)(b) clearly postulates that Act will not apply to other establishment not referred under Section 16(1)(a) of the EPF and MP Act belonging to or under the control of the central government or state government and whose employers are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefits. Stop. But Mr. Paul has clearly stated for this court. True, it is that the casual employees of OUAT are not getting the benefit of the contributory provident fund or old age pension as mentioned in Section 16(1)(b) of the EPF and MP Act. Therefore, those employees clearly come within the category of left out, quote unquote, left out. That apart, Mr. Paul and counsel has submitted that any dispute relating to services or subscriptions covered under Employee State Insurance Act 1948 are to be remedied by invoking the provisions of Section 75 of the Employee State Insurance Act 1948. Mr. Paul has illustratively referred to Section 75 of the Evidence Act, which catalogs the question of disputes which are to be adjudicated by the designated court or designated court, i.e. the Employees Insurance Court, in accordance with these provisions of this Act. For the present purpose, the District Judge Bhubaneswar is the Employees Insurance Court for purpose of the dispute emerging out of the dispute as catalogued under Section 75 of the SI Act. According to Mr. Paul, the disputes described under Section 75(1) within bracket small g covers and encompasses the disputes raised by the writ petitioner. Stop. For purpose of convenience, the provisions of clause G under section 75(1) is reproduced here under quote. First 75(1), then ellipsis, and then quote G, first bracket, and any matter which is in dispute between a principal employer and the corporation, or between a principal employer and an immediate employer, or between a person and the corporation, or between an employee or principal or immediate employer in respect of any contribution or benefit or other dues payable or recoverable under the Act, or any other matter required to be or which may be decided by the Employees Insurance Code under this Act. Irrespective of what Mr. Paul and counsel has submitted, it is apparent on the face of the provision that which kind of the dispute will be covered by clause G, and clause G is not a general provision to encompass any dispute emerging out of the Employees State Insurance Act 1948. Stop. According to Mr. Paul, the dispute that whether the casual employees of OUAT will be entitled to the benefits of ESI Act can be decided by a designated court, as it is a question of entitlement in respect of whether the benefits will be extended to the casual employees. Stop. In this, so, well, Mr. Pangari Lenisine Counsel, appearing for the writ petitioner respondent, has stated that the concern of Mr. Paul and counsel is entirely misplaced, in as much as regarding the ambit and extent of the section 16(1)(b) of the EPF and MP Act has been settled by the Apex Court in firstly, in Regional Provident Fund Commissioner versus Shanatam Dharam Girls Secondary School, colon 2007, 1 SCC 268. The Apex Court has proposed twin test to determine whether an establishment seeking exemption from the provisions of APF and MP Act. Stop. The twin conditions are: first, the establishment must be either quote unquote belonging to unquote or quote under the control of the central or the state government, under the control of unquote central government. The phrase belonging to quote unquote would signify quote unquote ownership of the government, whereas the phrase quote under the control of unquote would imply superintendence, management, or authority to direct, restrict or regulate. Stop it. Second subpara, the employees of such an establishment should be entitled to the benefits of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefit. Only if both the tests are satisfied by an establishment, both the tests are satisfied, an establishment can claim exemptions plus exclusion under Section 1B of the EPF Act. Stop. The same principle, i.e., the twin test, has been applied by the apex court in a subsequent decision in Common House Limited and others versus Aviation Karmachari Sanghatana and others. Colon. No, I'm just searching for the SCC reference. Okay. Which one? Only a different book. The copy maybe. 2020 13 SCC 506. Stop. In that case, the apex court having referred to the definition of the employee as provided under the Provident Fund Trust Regulation, has held that, has observed that out of a total workforce of 840 employees, the company had engaged 570 employees on regular basis, while 270 employees were engaged on contractual basis. Stop. So it has been also referred by the apex court that the central government, in exercise of the powers under Section 1 within bracket 3 within bracket small b of the EPF Act, issued a notification dated 22/3/2001, making the provisions of EPF Act applicable to aircraft and airlines establishments employing 20 to more persons, excluding aircraft and airlines establishment owned or controlled by the central or the state government. So the said notification was specific to the establishment of the aircraft or airlines. But the similar notification, that's the notification you have annexed to the C1. Your notification?
1682.
1682
notification which covers 18 cover. It's quoted in the judgment itself.
Okay.
This is the notification. It has been quoted in the judgment.
Please. General notification was issued by the central government on 18/2/1982 and gazetted on 6/3/1982, clearly laying down that all universities will be covered by the EPF and MP Act 1952. So,
Central government hereby specified the following classes of establishments.
no, that notification clearly said any university.
Following classes of
No, I'm
establishments.
just totally going to
It
the
need not-
class we are concerned with, yes.
Individual notification.
In this regard, Mr. Honorary Learned Senior Counsel has referred to section 1(3) of the EPF and MP Act, which stipulates the subject to the provisions contained in section 16, it applies to every establishment which is a factory engaged in any industry specified in Schedule 1 and in which 20 or more persons are employed, and to any other establishment employing 20 or more persons or class of such establishment which the central government may by notification in the official gazette specify in this behalf, provided that the central government may, after giving not less than 2 months' notice of its intention so to do, by notification in the official gazette, apply the provisions of this act to any establishment employing such number of persons less than 20 as may be specified in the notification. This provision is not applicable in the present case, as the strength of the university is much more than 20, and in this regard, there is no dispute. Stop. As we are referring to the decision of the Apex Court in Pawan Hans Limited Supra, the Apex Court has, in that particular case, has occasion to set out the fact. Stop. Approximately 370 to 400 employees were engaged by Messrs. Pawan Hans Limited on contract basis in various cadres, but no social security benefits is being extended to them. EPF and MP Act 1952 lists down that any person employed for wages in any kind of work or in connection with the work of the establishment, and includes a worker engaged by or through a contractor. So there is no distinction between a person employed on permanent, temporary, contractual, or casual basis under Section 2F of the EPF and MP Act 1952. Therefore, all the casual employees, it has been held by the Apex Court, is entitled to be come within the definition of the broader definition of the employee. Stop. In Pawan Hans Supra, also the contractual workers were not getting the benefits of the contributory provident fund, which was otherwise extended to the other employees, or under any scheme or any rules framed by the central government or the state government. Consequentially, the exemption under section 16 of the EPF would not be applicable to that company, as the company has failed to satisfy the second test. So this is the company, so for the extending the benefits of the EPF and PF Act is concerned, will not stand excluded. Stop. In the present case, no, Mr. Mohanty Leonard, counsel who appears for the Commissioner for the EPF and NP, the Commissioner for the Employees Provident Fund, has clearly stated that the casual employees of the OUAT would definitely come under the for having the benefit under the EPF Act. And for that purpose, OU2 shall not be excluded under section 16 (1) B of the EPF and MP Act. Stop. Having appreciated this question, in the light of the submissions made by the Land Council appearing for the parties, and also scrutinizing the records, we are of the view there is no infirmity in the finding of the learned single judge. And we affirm that finding. So for the question whether learned single judge was correct in exercising the authority under Article 226 of the Constitution for a matter which, according to Mr. Pal, counsel for the appellant OUAT, that the dispute can broadly be brought under Section 75, (1) small g, and as such, in presence of the effective adjudicatory mechanism, the jurisdiction under Article 226 ought not have been exercised. Stop. The aggrieved person, the writ petitioner, which represents the casual employees, should have approached the designated court for resolution of their dispute or grievance. Stop. In this regard, Mr. Pangari Leonard, Senior Counsel, what is that communication you pointed out? This state government communication?
No. I'll show myself. One minute.
Then the state government asks much.
Annexure 14
was referred Annexure 14.
Mallards. State government.
Is it a
14 and
petition
15. Annexure 14 and 15.
of writ petition?
Mallard bill petition. Government of Orissa, Department of Agriculture.
57, 58. Lordship will find at page 57 and 58 of the
Writ petition?
writ appeal, 57 and 58.
All right.
There are next.
Part of Annexure 1 series.
Yes, 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 ma'am. Page is 57 and 58.
Is referred to the communication of the Government of Orissa in the Department of Agriculture and Farmers Empowerment dated 23/7/2019, Annexure 14 to the writ petition, whereby it has been communicated that the provisions of the Employees State Insurance Act 1948 and EPF and MPF 1952 are applicable to the casual laborers engaged in OUAT. Therefore, the university authorities has been requested to implement those acts at their level. So, again, by the communication dated 25/9/2019, Annexure 15 to the writ petition, the university authorities are directed to implement these both the acts as referred before in respect of the casual laborers engaged by the university. So, Mr. Mohanty, Learned Council has also referred to another communication from the Government of Orissa, Department of Agriculture and Farmers Empowerment dated 6/9/2021, which is Annexure C5 of the counter affidavit filed by the opposite party number 5 in the writ petition. In the said communication, it has been stated, it has been reiterated that it has been stated by the government that the government has been pleased to approve the applicability of the provisions of the Employees State Insurance within first bracket ESI Act 1948 and Employees Provident Fund within bracket EPF and MP Act 1952, the casual laborers engaged in different projects of OUAT. So it was also requested to take an early action. According to Mr. Pangavi, Learned Senior Council, and Mr. Mohanty, Learned Council appearing for the Commissioner appeal, the dispute is not relating to the disputes that catalog under Section 75 within bracket 1 of the ESI Act, but is a dispute that despite the state government has taken a decision, approved and taken a decision that the ESI Act and the EPF and MP Act is applicable for the casual laborers of the OUT, they are not implementing it. And as such, according to Mr. Mohanty, that is a gross infringement of the Article 14 of the Constitution of India. Stop. Mr. Pangari has also adopted the same submission stuff. On the first blush, the submission of Mr. Paul and counsel appears very attractive. But when the scale is lifted, we find the dispute is confined to the implementation of the both the acts in respect of the casual laborers / employees who are working under the OUAT or under different projects of OUAT. Therefore, in our considered view, learned single judge has not committed any error of jurisdiction to be interfered by this court. Having observed thus, the view this appeal doesn't have any merit, and accordingly, it is dismissed. So, before parting with the records, we will direct the appellants to implement both the acts as referred above within a period of 2 months from today without fail. An urgent certified copy be issued on application.
Rather, direction would be the statutory authorities. They have failed in their duty. They have, in fact, we have gone with the inspection because statutory authorities have failed in their duty.
Even the appellants fails to implement, we direct the commissioner PF to take action as in accordance with law against the.
Yes, absolutely.
They have already taken action. They have already taken action.
No, already taken action. And so this and Mr. Paul, I have not recorded the notice issue. Notice only in respect of when certain establishment will be brought under this thing, not for taking action. If you are having the 20, it is automatic jurisdiction. They provide no notice is required to be given.
Yeah, 2 minutes.
So we take action, and we also make it very clear the proceeding has already been drawn, be taken to its logical end with all rigors. So it is almost 12:30. There is a matter I fixed at 15 called it matter first. Yes.
Item 3 only I just want to make a mention. Yesterday, a lot told me to file a additional affidavit in the registry. I filed it. So let it be brought to the record. I think it has not been brought it. So tomorrow it can be taken up.
Already this item 3, list the matter. Item 3, list
Tomorrow item. Because I think same item is the election matter.
3.
No. 3. Item 3, my lords, I'm appealing for the appellant.
Number 4, item 3, let the matter be listed on Monday next.
My lords, may I have it on Tuesday, my lords, I request. Monday is little, my lords, I'm appearing for the appellant. Request lords, may I have it on Tuesday? Subject to
item 3, you are not here, perhaps.
Tuesday is a holiday.
Item 3 is.
No. Item 4.
Tuesday is a holiday. Mr.
Again, my lords, may I have it on Wednesday in that case, my lords.
I'm sorry, Lord.
Wednesday is also a holiday.
Item 4 and 4.
All right, that is why.
Okay.
Not in 3.
Amar item 3.
All right, item 4, sorry.
It's going for item 4.
Yes, my
At the request of Mr. Ganasam Namthal and counsel appearing for the petitioner, let the matter be listed on Monday next. So it has been stated by Mr. Namthal and counsel that an additional affidavit has been filed.
Copy has been served also.
After serving the copy on the counsel for the opposite parties. So the same affidavit shall be brought on record for the next stage.
Monday, Lord.
Monday.
My lord, item number 15, the lordships are directly.
That is what it is.
My lord friend, on behalf of the respondent, he is present here, and he agrees that let this matter be called on Monday, 18th, and both parties will cooperate for final disposal of this without any adjournment by anyone.
Let the matter be listed on 18th.
And your lordships may kindly convey it at the top of the proceedings.
Item 15. So there shall be no accommodation on that day. That is granted to the counsel for the petitioner to mention on that day for upgrading the matter.
And moreover, they may kindly be directed to file written note of sufficiency.
You cannot direct anyone to written note of submission.
But order to mention matter. Item number 6, it is listed for delay of condemnation of delay matter.
Just one, that's not completed that order.
My lord, the interim order may kindly be directed to continue.
Tripathi, the counsel has appeared for the appellant, just Emma Pradhan and counsel has appeared for the respondents. Interim order as passed earlier shall continue till the next stage. Yes, your matter is for
item number 6, my lord. That interim order is already, there is not existence, my lord. It is already infructuous because the writ appeal they have filed challenging the order of the single judge. That interim order is no more existence. It is already infructuous. All exercise will be futile because there it is listed for condemnation of delay. The learned single judge already said that a new writ application has been filed and that is notice was issued and it is pending. They said that no opportunity was provided to file the counter affidavit here. I don't know how input that order I am supplying. That order already granted. Please kindly go through.
Yes.
I am just handing over this order. One more copy, please. Another. And this is the new writ application notice.
It is a contempt case.
Number in that contempt case, the Honorable Single Judge granted liberty to file a fresh writ application to test that order. One Single Judge said that we cannot interfere that so far as the order passed by the. This is the latest order and notice was issued.
Paragraph 4.
What has happened in this case?
No, see the paragraph 4. The order direction was.
Yes, what are the direction? Direction were to consider his case in accordance with another case. If that has been rejected and he has challenged the in a fresh petition, so this petition has become infructuous. Recording his submission, your lordship can dispose of it, my lord.
Always.
If order was going to be complied with, why have you filed the writ appeal at all?
Why you have filed that there was a direction taking into account another case. If simple direction was that to consider his case, we could not have filed any writ appeal.
Then you should not have taken
In
decision.
the meantime, that has been rejected and they have challenged it in a fresh. So this has become infructuous, what my learned senior says.
Yes, I have some.
Disputing.
P. Panda, Learned Counsel, appearing for the sole respondent.
1 and 2.
1 and 2 respondents has produced a copy of the order dated 10/7/2023, Bastin CONTC number 3946 of 2023, where it has been recorded that order which had been passed by disposing of the representative of the petitioner as directed by this court in WPC number 2072 of 2023 No, that is let's say. Whether this we have challenged the Nirmal Chandra Maharana's case also.
No, no.
So that order is going to be submitting that.
Yeah, that I am also agreeing with his submission.
You are agreeing with the submission. You have challenged the order of the single court.
This court.
So if this has become infructuous, then order stands.
is not in compliance to the order passed by this court
In light of the
in the above noted
We challenge that
petition.
it is not in the light.
He further submitted that this court directed that
So,
it has been also recorded by the learned single judge that the case of the petitioners be considered in the light of the Nirmal Chandra Maharana. Stop.
That order stands.
that's the problem.
So it is school of the court. It is the reason Parliament and Council, I think, referred to such instances, has stated that the appellants have complied the order dated 1/6/2023 against which this intercourt appeal has been filed. Stop. They say that order has been complied with by the order dated 1/6/2023.
But at 1/6/2023, they have rejected. They said that the case of the present respondent number one.
Order dated 8/2/23 has been complied. My lord is asking.
No, they have not complied.
That is rejected and that has been complied.
Passed by the Principal Secretary to the Government of Orissa, Housing and Urban Development Department, Bhubaneswar. Stop. The direction that was given by the learned single judge by the order dated 8/2/2023 in WPC number 2072 of 2023 is to consider the representation of the writ petitioner in the light of the case of Nirmal Chandra Maharana. Stop. Mr. Pandal and his counsel has submitted that challenging the said order dated 1/6/2023 as passed by the Principal Secretary to the Government of Orissa, Housing and Urban Development Department, Bhubaneswar, a fresh writ petition being WPC number 23155 of 2023 has been instituted by the respondents. Stop. A notice has been issued on the writ petition on 27/7/2023, a copy of which has been produced before us. But the learned counsel has on consensus that in view of the said development, this writ appeal itself has become infractuous. As said, the writ appeal stands dismissed as infractuous. Interlocutory application, if any pending, is also disposed of. The copies of the order is produced before us shall be taken in the record. Next.
Item number 3 to be called out. 9.
Item number 5.
Item 9 that indicates.
Where is item number 3? Where is Mr. Are you agreeable with the matter?
My lords, lordships had asked us on the first date. An officer can be appointed.
No, they have disagreed. This chapter is over now. They have disagreed. No, that we have already passed the order.
My lords, that was to be. My lords may see the order dated 18/8/2023. They never said anything. Mr. Sanganari was appearing for the respondent. Lordships had posed a query whether they're agreeable to their proposal. Yesterday, Lordships had suggested if any member of the High Court Bar Association.
No, they already and one advocate is carrying on. They said they did not say directly that we are not agreeable, but they said that one advocate is already on the task. So why another advocate? That was their condition. Am I right?
The advocate was appointed. The advocate was appointed.
Senior most advocate.
Then what is the submission of Mr. Bhuya?
One of the senior most advocate of Kinger Bar has been appointed as the election officer, to conduct the election.
By the advisory body, my lords, whose existence.
Not by advisory body, in consultation with the
advisory body has been annulled by order dated 1/8/2023. my lords may see the order of the learned single judge. That is, my lords, in WP, that is at page number 57, my lords. The existence of the advisory body has been annulled after considering all the precedents of this court. This court is in unison except this impugned order that this court should not interfere in the election process, my lords, on the face of section 11A. 11A is an amendment that was inserted under the provisions of Societies Registration Act. It says that all provisions pertaining to elections, continuance of office bearers shall take place before the civil judge senior division. My lords, for a moment, can we have the amendment, my lords? 11A, my lords.
Yes.
I request my associate to hand over the copy of the amendment. Whether an election officer, my lord, the question that arises whether an election officer can be appointed at the behest of the advisory body who has no existence as on date. There is no advisory body, my lords.
We will not be able to complete this matter. Better we take up the smaller matters and we pass the order. Can you complete your submission within 10 minutes?
My lords, my submission is on a narrow compass that the electoral roll should not have been finalized. There cannot be any direction that the electoral roll be finalized by the ADM. It's a matter within the association, within the governing body and the association who has to take a call regarding the electoral rolls and the conduct of elections. That is exactly what is the scope of section 11A, which has been inserted by virtue of the 2021 amendment to the Societies Registration Act. Now let's have a look at the amendment for a moment. That will solve the issues as far as everything is concerned. There cannot be any jurisdiction of this honorable court. This will open the floodgates, my lords. This will open an unprecedented floodgate for all times to come. Every time there is a dispute in any society, they will rush to this court, and this court will be burdened with unnecessary litigation regarding the private affairs of society. My lords, we see 11A, that is at page 3 of that amendment act. This was not there in the original act.
Yes.
And possibly because of the 2018 order of this honorable court with respect to the self-same association, this court said that
this provision.
Sir, এটা পুরোনা ওইটা নয়া ওইটা amendment আছে 2022 edition the amendment আছে
You are not aware of this amendment?
Yes, ma'am. I've got it. Now, my submission before Lordship kindly see.
Mr. Mohabbat, we take up the matter as the first item tomorrow.
Tomorrow?
First item.
First item.
Let the matter be listed. Tomorrow, give the date.
Let the interim order be continued.
At the top of the list, considering the urgent nature. Considering the urgency. There shall be an attempt to dispose the matter on merit. We would request the learning council representing the parties to prepare a short note for convenience of the court. Mr. Prashanjit Mahapatra, learning council appears for the appellant. It is Mr. D.K. Mudoli, or you are appearing today? Mr. D.K. Mohanty, additional government advocate, appears for the state opposite parties number 1 to 5. And Mr. Anirudh Sangaria, he is not today there.
On behalf of Sangaria, I am yes.
What's your good name, sir?
Isnath.
Mr. Isnath, learning council, appears on instruction of Mr. Anirudh Sangaria, learning council, for respondent number 6, and Mr. Udhivas Mohanty, and council appears for the interveners. You are appearing for whom, Mr. Ram?
Intervener. My application for intervention is long since pending me.
All right, tomorrow just you please it.
And I think Mr. Mahapatra is also now appearing for intervener. He is no more for the appellant.
For the appellant, my lords.
He is no more holding power for the appellant. No, he has substituted.
Substitution has not been allowed. Substitution 8. So what is the difference?
My lords, may I request, because technical objection has been raised, substitution may be allowed, my lords, that I had filed.
No. Your lordship may see the rules. He is no more the appellant. He is not holding power for the appellant. The appellant is already
I have filed a fresh wakalat. I have filed a fresh wakalat, my lords.
Now the question is, he cannot address on behalf of the appellant.
A fresh wakalat has been filed, my lords. He is not aware. My learned senior is not aware. A fresh wakalat has been filed on behalf of the association.
No, not appellant. Appellant is Savindra. The appeal is supported by affidavit of Savindra.
I have substituted that. I filed an affidavit. I filed an.
But that affidavit also cannot be substituted. The affidavit also goes.
Special mention that government is already fixed.
This
will be the second matter.
Friday. Right. 15.
My lords,
Friday.
also, let the interim order be extended till then, my lords, till Friday. Because the process is still on, my lords. Despite the advisory body being annulled.
Well, that is exactly the difficulty your lordship may kindly see. There are 5 to 26 orders passed by the honorable single judges which has never been challenged. Now your lordship is passing an order. The ADM is now put between the dilemma of two hands. If you observe your lordship's order, he is committing contempt of the order.
I have brought on record all the orders, my lords. All the orders have been filed on record.
Right.
We have not passed any order directly to do anything.
Right. No, this one of the case, one of the honorable single judge of this honorable court has directed the ADM to intervene in the matter and do the needful. And that order is not challenged. That is what unless that order is annulled or set aside, the ADM's powers still exists.
No, my lords, there is a small confusion. The ADM had directed the. My lord, the ADM had directed.
Also, your short submissions.
Advisory work is objectionable, purely objectionable. Lordship, they are conducting election on bail basis. Lordship,
already make these appearances.
right? Lordship, right.
What's been having it on Friday, my lords?
I think there's an odd change.
Item 5. Item 9, sir. Item 9.
Item 8.
Item 5.
Item 9, sir, please.
Yes.
Well, whichever outcome of so the document has been e-filed. I am placing a hard copy in the lordship. That your lordship's last direction was to dispose of 14 tons of ganja. In the meantime, we have disposed of more than that. Now you'll also get it from page 2. It was total, it was disposed of on the last date, it is 290 tons and some odd. Now it has come to 337 tons, page 2 plus. 2 quintals and 46 kg of ganja and 70 kg, 808 grams of and 915 milligrams of brown sugar and 94 kg and 494 grams and 20 kg of poppy straw, then opium of 790 gram and 29,719 bottles of codeine. And paragraph 3 also, that is where the certificate process is complete in respect of 36 tons, 6 quintals, 60 kg and 606 grams of ganja. That has to be destroyed. Only I want the principal judgment, main judgment which has been passed by the Supreme Court on 31st January 2022. There at paragraph 25, page 17. You will also kindly peruse that. I want little modification subject to Lordship's appreciation. Additional direction, not modification, additional direction. This process can be a little faster. Page 17, para 25. Judgment dated 31st January 2022. Plus, I am clause 1. I then I'll go to clause 3. All pending applications shown in Annex 3 to the petition shall be taken up forthwith by a first-class magistrate, specifically nominated in each of the respective district by the district and session judge, who will deal with such applications exclusively on all working Saturdays of the month till the entire backlog is cleared. If the number of such pending cases is large in a particular district, the concerned district and session judge will nominate more than one magistrate for that purpose, who will take up the application likewise. Clause may come to clause 3. There shall be strict compliance with the guidelines issued by the Supreme Court of India in Mohindal. All the applications under section 52A, section 2 to 4, NDPS Act pending for the learning magistrate in the different judgeships in Odisha should be disposed of within a period of 3 months from today. In any event, on or before 1st May 2022. But that could not be done because of more number of magistrates could not be nominated by the learning districts. That's the reason why backlog is not clear, because now 1/3, at least 1/3 we have cleared, because another 700 tons of ganja still lying at different places. So Last may kindly direct so more number of magistrates to be nominated by the learning districts, and so far as the Saturday, working Saturday, suppose any Saturday is holiday, any working day prior to that Saturday, maybe Friday or any other day.
Nomination of the list number of population list in terms of the other regions. One the direction is building not be fully applied with the direction that you what it exactly leads to 1 year. So all when we application The district section judge will be certain conditions all the services in the entire law is created. If the number of special cases is large in the district, the council district magistrate subsequently nominate more than one magistrate to be proctors to trigger the applications like this. The subject by that all the applications under section 52A that it is pending and the actually in would not be disclosed within the stipulated time and 3 months. And when the law estimate, one third of the total.
Yes, about 1/3. So backlog, 1/3 of the backlog. Yes.
With disposal of the explain to the when we click on the same and also the district values considering the very dominate the equation of and they should also be allowed to take up their strategies. We cannot find and person search direction walking to for the team after the same or the the session of the it takes stock of the develop of the patient organization. Two people make these apps and money. A good number of students we work on both sections in the IT school. And any other day to meet the to dispose of the material. Literally, we have to another 3 months. We wanted to employ the direction sort. Moreover, in religions.
Unless
Mr. It would be a concern. That's why the compliance regulation interrupts over other things that can try to think but in the same regulation, it transpires that India internet 314 jobs, 3.7 and 980 graph in 1,991 cases. 76 pages, 808 grams of pages of blood, 175 cents. This food keep stage. 9 grams, 67 kg, in 133 cases. And 92 kgs stored in blocks and coffee stock. In one case, and destroyed as destroyed the disposal. So it is also stated that 3 blocks 8 contains 65 kgs and 12 blocks of container 2 kgs coffee foods and disposal as unidentified blocks being received from the distribution of Nigeria, the remains 29,719 bottles of codeine, which approximately cases. So there will be 790 grams of cocaine in our case with this point of the state of the government able to show the programs of different categories of items the initiative taken by the
Orissa State
Police.
Orissa State Police, no, so can say. No, still no, State Police. I know. And also the judicial officers who are on the job does.
You are also noticed, right? We just submitted the police of someone to
Yes, only 5 dishes are furnished.
What is the necessary information?
Yes, as per what's direction.
And on the basis of the same information, the same.
Yes. Person, because you are also directed in the last by the last order.
We direct the remaining superintendent of police to furnish us information by the next week. That will be still on. The week of October 2023. We also direct the other superintendent of police.
Other districts.
Other districts to furnish the updated information.
Maras. Maras.
Before the date,
what?
Compiling all the information that we received from the district regarding the disposal and jobs for order. Further recommendation is filed.
One more submission loss that I have left out, due apology loss. That in clause 3 on the last line I'm reading.
Clause 3 or what?
All fresh applications filed hereafter will be endeavored to be disposed of within a period of 10 days from the date of their filing. The endeavor, last but not see not later by the end of 10 days, the application should be disposed of. Because all applications what we are filing.
Telling anything will be better for you. Because of specific, sometimes the process could not be complete. Sometimes somebody is cut out.
Yes.
Then it will be open.
Yes.
Go on the same process, I think it will be better.
Repopulation.
Here, my lord, the petitioner has challenged item 5 here. Yes, yes, my lord. My lord.
What is your basic ground to challenge the environment?
My lord, I am chief executive of the basic ground, my lord. It is in violation of section 34 of the Rights of Person with a Disability Act. May I read?
So relating to recruitment, and that your lordship may say he is no way affected, and also the representation, the defect must be there, madam, that annexure 6 here, annexure page 32. There is no proof of service of that representation.
Do one thing. Who is appearing for the Office of Public Service Commission?
Normally, Mr. P.K. Mahathi, Senior Counsel appears.
Not Mr. Tripathi?
Not, yes, Mr. Tripathi.
Yes,
Actually, what it matters.
Can you say what is the stage of the
My lord,
do you have any instruction?
I don't have an instruction, my lord. Let him give me a copy, my lord, so that I'll be able to take instruction.
My lord, the last date for recruitment is 19th September, 18th September. So I have also filed for a stay.
Because you will not be affected, I am telling you why.
What is this case?
The vacancies will be available.
Yeah.
My lord, they have 291 posts for one category, that is physically or handicapped. But they have to cover all categories, like vision impairment, hearing impairment, and for deep,
especially functional post, my lord, as your lordship knows, one of the matters where I was arguing.
No, unless because you have to exempt by exercise of
the power, my lord, which is there. Completely.
You have the power and you have to accept an exemption notification must be there.
2013, I think there was a notification, my lord. We will be able to get back to lordship if lordship fixes matter.
Come on Monday.
Monday.
18th will take up the matter.
18th.
Mr. Monday.
Right. Item number 12. That Kundagora matter. You will so substantially hard and rendered me kind indulgence because of the NEET examination the son. The father has also filed that has been charged. Maybe at the top.
Item 11. 11.
Sorry, 11. Item 11.
21st September. 21st September.
Right, madam. At the top, my lord, I request.
Another crave lordship's indulgence, my lords.
Item 12 taken up.
Permitted, my lords. Item 3.
Right. Item 12 taken out tomorrow, my lord. Today.
Next 2 days, I have some issues. I will come next to applications.
Lordship, I crave.
In that item number.
I'll ask Monday, lordship, today.
Let you come on Monday, your lordships.
Lordships, I crave your lordship's indulgence. Lordships, in item 3, lordships, I have just been informed that a similar writ appeal has been filed on behalf of the association. My lords, that may come on Friday. Lordships, I pray that I'll give the writ appeal number.
What petition you have registered on the basis of that? This is not the way suddenly you interrupt in the proceeding.
I'm sorry, my lords, I've just been, because that matter is coming on Friday.
I just mention on Friday. Mention on Friday. See it.
If you want the other writ petition, you can mention tomorrow. Monday.
Item 8. Item 8. May taken up tomorrow, madam. No. Item 8, madam. Next week it may be.
I has been filed on 14446 of 2023. I filed, my lord. I has filed on 11th, my lord. Yes, ma'am.
What is the subject matter in the
Yes, my lord. On detailed report filed by the amicus curiae, my lord, it is in the second para. It is mentioned that in Nattamandap main beam, there is important catastrophe may happen at any disaster may happen at any time, my lord. So, my lord, I has been filed to immediately start the work on it, and it will be.
All right, on Monday next, please come on Monday next.
Item number 10, it's a PIL where the RERA is not executing its order, it is sending it to civil courts, which is but the statute provides that the RERA should execute its order. So, my lord, it's some urgency is there.
No, there is no.
My lord and friend is trying over this court to come up with a legislation. No, not that. Statute, it's battery, all of us battery.
Mr. Agarwal says the statutes provides
all over the country, the civil courts executes it. So OPDR proceedings are also being initiated. One is execution of the order, we send it to the civil court. The other one is OPDR proceeding. My lord and friend says that all this must be done by the RERA. All over the country, my lord, the legislation.
No. He says there is a specific provision.
Let us see. Rule 26(2) specifically is there.
All right, we'll hear the matter.
Yes. Also fix it up to next week, my lord, some days.
Next week. 27 new matters should be listed. Not on 26, 27, 28, no matters should be listed because I may not come also in the court of those days. It will go to the October.
Yes, well, October.
5th of October.
5th of October.
Only one arrangement if your lordship can do. In the meantime,
Without hearing. Without hearing.
In the meantime, only the RERA should not transfer the matters to a civil court because by completely frustrated.
Matters don't worry. Each matter will be referred, you'll recall all the matters.
Because hundreds of cases have been transferred there.
Always. We'll recall. We'll ask them to recall if you can succeed and convince this.
Well,
Always.
5th of October, you would say. Yes. Deeply.
Always.
Not come read appeals, you also. My lord, Mr. Sahu is there, on the other side, and we are together in the same 29 writ appeals. Can it be taken up tomorrow, your lordship? This is a providence matter, and the appeal had been hard and hard and short, your lordship.
What is the case number?
426 of 2016.
You just check. You're trying to account.
Tomorrow, fine. Very good.
Page 1, item 1 to 6. Page 2, item 7 to 12. Page 4, item 13 to 15. So, submission item number 1.
If I may please your lordship, I would like to humbly apologize your lordship. On last occasion, your lordship had directed me to file an amendment petition inculcating a ground for challenging the finding of the learned single bench with regards to the election dispute being amenable only under 227. I have prepared the amendment petition, Your Lordship, but due to certain reasons, it could not have been filed beforehand. I can file it today in the registry. I have served a copy on my learned senior as well.
So all right, you file it, we'll look into it. All right. Yes. Make your submissions.
My lord, they have served me the copy just now. Petition for amendment.
You need to examine.
No, my lord, I will not file any counter, but the ground which is taken.
Yes.
My lord, the London single judge has not treated that it is a matter relating to election tribunal and he has not exercised power under Article 226. Only thing, my lord, your lordship is to see whether the order passed by the London single judge is exercising power under Article 227 or 226, my lord. Here, the amendment which he has sought for, the ground, reveals that the London single judge, even if knowing that it is an election tribunal order, have not exercised power under Article 226. It is not the case which is before your lordship, man. Whatever it may be.
Because he has wanted to incorporate one ground.
Ground that even if it is beating that not exercise power under Article 227, but the import of the order itself reveals that the London single judge has exercised power under Article 226. That should be the ground. But whatever it may be, lordship may have this.
Yes. You are appealing for the appellant.
Yes, Your Lordship.
Yes.
Your Lordship, my submission, I'll recapitulate this quote with regards to my submission previously made, Your Lordship. My submission in gist was that the election tribunal, even though headed by a civil judge junior division, is imparting a power not of that of a civil court per se, but rather is functioning as a tribunal. And under Article 226, tribunals are amenable under Article 226, Your Lordship, which has been stated by the 2015 judgment of the Supreme Court in Jogendra Singh Ji. It's a division bench matter. Your Lordship had asked specifically to me to go through the case of Radhesham versus Chobinath, Your Lordship. I went through that judgment as well. Radhesham versus Chobinath specifically deals with the matter of issuance of writ of certiorari to civil courts, Your Lordship, imparting a function as per the Civil Courts Act and functioning as a quintessential civil court, Your Lordship. But, Your Lordship, in that same judgment, in para 10 of that judgment, Your Lordship, the Apex Court has taken note of a case, Your Lordship, in P.S. Bassappa versus T.S. Nagappa, Your Lordship. It is AIR 1954, Supreme Court 440 in para 10, wherein this contention has been detailedly discussed with regards to the election tribunal exercising its power. And it has been stated that it is amenable under Article 226, and the said order of the Supreme Court of 1954 was not set aside by the Apex Court in the case of Radhesham versus Chobinath, Your Lordship. So my submission, subject to your acceptance, Your Lordship, is that the said view taken in 1954 Supreme Court judgment is still valid, Your Lordship. So also, Your Lordship, I have gathered two judgments of this honorable court, Your Lordship, division bench court. As per the clause 10 of the letter patent, Your Lordship, election writ appeal arising out of election dispute is amenable under 226, and writ appeal lies to the division bench, Your Lordship. Hence, my submission is that the question of maintainability that was raised by my learned senior, the writ appeal at hand is maintainable. Coming back to the case of the learned, the judgment, the order passed by the learned single judge, Your Lordship, I may direct Your Lordship's attention to page
49, your lordship, para 6. In para 6, the learned single judge has categorically stated that for the second provision of section 31(1) of the OGP Act, there is a power vested with the civil judge junior division, being the election tribunal, to condone delay provided it finds sufficient cause existed there for failure to present the petition in time. There has been assessment by the civil judge junior division through Annexure 3 finding sufficient cause existed in bringing the application subsequent to time stipulation. It is immaterial whether there is a delay of 51 days or 48 days. Keeping in mind view the reason assigned in delay condonation application, such order has been passed in exercise of power under section 31 of the OGP Act. In the circumstances, this court finds there is no defect in the impugned order requiring to be interfered with in exercise of power under Article 227, your lordship. The whole question arises out of this paragraph, your lordship, because the learned single judge is assuming that while he is trying a case arising out of an election dispute, your lordship, he is exercising a power under 227 only. But my submission is contrary to that. Rather, it is both 226 and 227 which are in operation, your lordship, while he is examining a matter arising out of the election dispute, your lordship. So with your due permission, your lordship, I'll move to my case at hand in the writ appeal, your lordship. The short fact of the matter is that I am the winning candidate, your lordship, the writ appeal, appellant. The election, your lordship, took place. Election took place, your lordship. The result was declared on 2nd of March 2022, your lordship. And as per the section 31 of the OGP Act,
So Bhuya, if we are ultimately holding that writ appeal is not maintainable, and so then what is the point in hearing the matter on merits, and it's an election dispute?
your lordship, my submission is that if your lordship holds that it is not
that category, could you find out that that enlistment of the cases, which type of cases? Latest patent appeal is not maintainable. Also, our full bench decision. There is a list. Could you get that decision?
No, your lordship, I haven't gotten that decision.
Chavinath is one. Then
Jogendra Singh Ji is another, your lordship. 2001
by Justice, if I remember correctly, Honorable Chief Justice Deepak Misra.
Yes, your lordship. And that is Jogendra Singh Ji.
And Justice Goel also.
Yes, your lordship.
So how do you is Justice Goel, my lord?
The last in that list, the last entry, just mark or any other authority. It says even to that extent the court has said that if it is exercise of power, so because it has a relevance, because you are trying to distinguish that it can be as well as a 226, but somehow you are candid enough to say that it is 226 and 227. So even 226 at times is difficult to say that a writ appeal is maintainable, much less 227. 227 definitely not.
But your lordship, my submission, subject to your acceptance, in the
under which provision of the Gram Panchayat Act? It's a negative question. Please appreciate that. Writ is maintainable before the High Court.
Your lordship, under section 31, the principles has been laid down as to when election dispute can
election dispute is to be filed before the election tribunal.
Yes, your lordship.
So that is well taken. But if you say that yes, it can be 226 also, under which provision of the Gram Panchayat Act 226 is possible, not going to the tribunal? you can straight away come to the High Court. But your lordship, because I for that reason I clarified you that it's a negative question. So in fact, it is a subject matter of the election tribunal and it is 226 read with 227 and this court has exercise power under 227. Because if your argument is to be accepted that the court was exercising the power as an election tribunal, then obviously it is 227, but yes, it can be also 226 certiorari proceeding, it can be. In both the cases, 226 certiorari, when the subject matter of challenge is the order of a tribunal, then it is writ appeal is to be not maintainable.
But your lordship, in that Joginder Singh ji's case,
because if you expand that way, if you interpret that way, then each and every order is writ appeal, letters patent appeal is maintainable.
your lordship, my submission to that question is that if the order at hand is purely a Article 227 exercise of under Article 227, your lordship, and in that case, the writ appeal is not maintainable.
No, to support your contention, you cite that decision where it says that it has to be, this court has to find out whether it is purely 227, purely 226, or a mix of 226, 227.
Your lordship, that is the case of, that is the judgment passed by learned CJI Deepak Mishra, your lordship, Justice Deepak Mishra.
Then the lordship has only, because that's observation, you just, lordship has summarize the entire thing at the end. Just find out that.
It is in para 45 as your lordship is mentioning. But your lordship,
can you para 45?
Para 45, last paragraph, your lordship. Wherein all the findings has been listed in a just manner.
Yes.
But your lordship, in that case, if the
whole, see, you are basically, your endeavor is that this court should embark on an exercise to find out whether it is a pure 227, pure 226, or a mixed 226 and 227. So the procedure is whether this court can do that.
Yes, your lordship.
No.
In that judgment, your lordship, that liberty has been given to this court. That even if the single judge power.
Kindly give the citation.
2015, volume 9, SCC 1.
15.9.1.
Yes, your lordship.
Why don't you display that in the here?
Copy extra new eta de debi mo pakde online achi.
Any difficulty?
May I permit to play, give this copy, my lord?
I have a single copy.
Yes, 45.
Good answer.
The lordship, can you see paragraph 20? Where the apex court has held that the writ appeal court will examine whether the order is passed under Article 226 or 226.
No, it is examined. But the thing is that it is apparent when they are on the face of the record. Can we go behind the mind of the single judge? We are on our interpretation will say that it is 227 because the caption is 226 and or 227. Fine. There is no difficulty. Yes. But what is suggesting that once we have to again re-examine that aspect because it is for the honorable single judge.
And your lordship has to re-examine.
No, we can buy, but if we are re-examining, then it's a clear case of 227.
Yes.
It's a clear case of 227.
Yes, yes, my
But
lord.
since Bhuya is making an endeavor, it's
Madam, what dismissing the writ application, further order was passed.
and Mr. Bhuya, yes. So that he has again, you see, the case is pending there.
Further order was passed.
Whether the 40 delay has been 51 days delay is justifiably condemnable or not. How can the Honorable Single Judge even suppose, even the Supreme Court has said, by merely observing that it is a 226 decision, 227 decision cannot be said to be 226 decision.
But your lordship, on the vice versa is also applicable. Even if the single judge is mentioning that the power exercise is under 227.
No, vice versa, you just find out where is that line.
But your lordship,
the first part is there. The single judge by exercising 227. But that is how what Ms. Mahapatra is saying, that even if the single judge says that I am exercising jurisdiction under 226, but whether actually it is 226 or 227, we have to find out. So it is not the other way around, that even if it is 227, will it find it out that it is 226? It has a context. Because the adjudication under 227 can very well be said to be by the Honorable Single Judge to 226 because it is a certiorari proceeding. And the tribunal is subject to the certiorari jurisdiction. On the face of it, it is not 226. Yes, para 20, then para 45.
Yes, your lordship. Because your lordship, in that case of Jogendra Singh, ample amount of power is given to this court to examine that matter. And even if there is a shred of 226 involved in the judgment at hand, in that case also writ appeal is maintainable.
Where is that? Where is that line?
Lordship, mark copy is there. I'll find that.
It is not there.
Because I mean, because the plastic.
Because initially there was some kind of confusion or some kind of fluidity. But after, you see, Radheshyam has been followed in Jogendra Singh Ji.
Yes, sir.
Jogendra Singh Ji has listed that also. And in that 45, it nowhere says that a semblance of 226 power, assuming accepting your argument, will say that yes, there is some semblance of a 226 power. Who will exercise writ appeal jurisdiction or letters patent jurisdiction? That is not there. Rather, it is the converse. If there is a semblance of 227, then writ appeal jurisdiction is outstayed. The appellate jurisdiction is outstayed.
But your lordship, as per my understanding of that judgment, even if at the same time both powers are exercised, for writ appeal to not be maintainable, it has to be purely under 227, your lordship. That is my understanding.
That is not there, sir. Again, I'll repeat my question because you started there. That proposition is not supported by the decision of the Honorable Supreme Court in Chavinath or Jogendra Singh.
But your lordship,
rather what you are saying, the contrary is available. Even the court narrating a particular adjudication to be 226, still this court can find no, even if it is narrated to be exercise jurisdiction under 226, still 227 is there. Like this is a classic case. Suppose let us assume in your favor that the court has held that it is a 226 exercise of power. Can it be? The letters patent, the intra-court appeal, this court will decide that no, it's not a 226, it's a 227. Because against the interlocutory application, you have challenged here in High Court.
No, lordship.
So that is how I am asking that question, that whether any provision is there in the Gram Panchayat Act where you can invoke jurisdiction of the High Court in 226. There is no such provision. Either you are challenging the final order or even you are challenging the interlocutory order. And more so in case of interlocutory order, it is 227.
But your lordship, if the limitation petition is rejected, it amounts to a final order.
Then as far as the final adjudication is concerned, there you can have an argument. Yes, there is a possibility of plain and simple certiorari 226, what you are trying to argue. But in case of interlocutory adjudication,
but your lordship, what my submission is that once a limitation is condoned, it becomes an interlocutory order, your lordship. But once the limitation is not condoned,
do you mean to say that you are abandoning your right to challenge the ultimate decision?
No, your lordship.
Then, but your lordship, in ultimate analysis also, if the court is holding against you, suppose the court is holding in her favor, I mean the respondent's favor.
If the court is holding in,
you see, by interpreting in that truncated manner, this will be the problem. This court decides, as Honorable Single Judge decides a matter, interlocutory matter, as far as, in the sense, finality, as far as the adjudication of limitation is concerned. Still, it is open for you, if you are agreed by the final order, or the other side is agreed by the final order, to say that continuation of delay is contrary to so and so factually or legally, whatever you cite. So how can you preclude that now?
your lordship, with regards to the limitation.
Still that order, that final order that would be passed by the tribunal is to be challenged, can be challenged by either of the parties.
Yes, sir.
Here, the finding of the tribunal regarding limitation as is against you, if ultimately it goes against you, that is still available.
Yes,
and suppose as a matter of prudence, you have gone to the Honorable Single Judge. Honorable Single Judge has not hold anything on merits. The Honorable Single Judge has simply held that, yes, delay could have been condoned. But still that, since you will be challenging that, that ground will be available to you. This another thing, what will be the finding?
But your lordship, with regards to the finding given by the learned single judge, the principle...
Radheshyam Chabinath, you have to say that this part permits this kind of interference by this court. And also, whether in Joginder Singh ji, whether there is any, which part says that we can ourselves find out, and if we are concluding that it is 226, then we will interfere. If it is 227, we will not interfere. It's not there.
I'll re-examine that question, your lordship, because the paragraph, your lordship, I'll humbly apologize, I don't remember exactly the paragraph.
45.
I have to.
Joginder Singh ji, we are holding Joginder Singh ji for
Joginder Singh ji copied. With regards to upholding Radheshyam, your lordship, that is paragraph 18 and 19 of the decision. The paragraph 20 talks about the looking into the matter that even if it is passed under 226, if it is a 227 power or not. But your lordship, on the contrary.
But you are saying, even if it is passed under 227, this court will find out 226. That is your summation. So where is that?
Your lordship, I'll examine the matter. It was between paragraph 20 and 40.
You are just repeating the same question every day. That is the whole issue now for us.
Obviously, I could guess it because when you said that my lord asked you, Radheshyam Chabinath, then I realized that what was the question.
But your lordship, my submission is that
you just read this paragraph. This whereby the Radheshyam has declared Surya Devra is a bad law. Why the background and the perspective factor in that case? Surya Devra says whichever is not covered under section 115, all is challenged under 227. General omnibus challenge can be carried out. Even also 226 to a greater extent. And that create a lot of problem in the judicial process. Then matter fall for consideration. There was a contrary decision in the Supreme Court and it was referred to a 3-judge bench. And the final outcome in this Radheshyam versus Chabinath is a 3-judge bench's opinion. They say under no circumstances any order passed by the civil court can be challenged under Article 226. Complete ban. So it has to be challenged. If you want to challenge for any circumstances, that has to be challenged under Article 227. Here is a unique question that you have raised on the last occasion. This is an election petition. Whether it will become, the court will come under the definition of the civil code, or the petition can be treated as the suit or not. That is a question that you have raised. Even if not, that we agreed that it is a election tribunal, it is not suit but a petition. Then also whether that will come under Article 227 or 226. Answer must be under Article 226 because it is a judicial process. Then you read Radhesham. Why they say 226 will not lie. They say the certiorari under Article 227 is a different kind of a certiorari. It is not the ordinary certiorari under Article 226. It is a different kind of a certiorari. Why? Because it is with a pertaining to a judicial process, question of jurisdiction, question of the authority, question of applying the law, everything can you brought under, and that must be under 227. Unless you can show, naturally we will draw this inference only. Because this 2015 case also, that you will find that just they have extracted the paragraphs from the paragraph 45, and before that also paragraph 16 of their judgment, where they narrates the question. And 45 is very clear, says no 227 in respect of the other matters, only 226 when you are challenging the various other action, not coming under this. That day you argued a point, but you did not develop, you left it in the lurch. You argued that industrial tribunal's orders are challenged before this court under Article 226. Then why the industrial tribunal's order challenged under 226 here? Why the election tribunal's order cannot be challenged under 226? You drawn a parallel, but you have not worked on that. Because you must remember, when a practice starts in a court, practice starts on the basis of an exact act or the provision at the point of time. Nobody has scrutinized whether also the industrial tribunal should also come under Article 227 or not. This question was never examined by the court. If you raise the question that I expected you raise the question that why it should not be under Article 227 and that the old practice of the court should be followed, as in the case of the industrial tribunal, which is also a judicial process for all purposes, can be adjudicated under Article 226. Why not in this case? Why this should not be taken in that way? But you have not worked on that. You have come with a different set of arguments. So very difficult to follow. Justice Sahu is new in this bench because we are hearing this matter for 3-4 occasions. We have heard you.
I'll develop my arguments with regards to.
Already we are fixing the matter in the month of November. Take time. Okay. The 11th November. I think this is we can right now dismiss your appeal. I'm telling you.
Yes.
The para 45 clearly says not to permit. What to do, tell us.
And that helps, perhaps it doesn't help also prolonging litigation here.
Yes.
When the case is pending and you are the elected candidate.
Yes, Your Lordship.
So that may help you.
There is no interim order. There is no interim order.
No, his case is not pending. His case is consequentially disposed of.
My love, case is pending. Case is pending.
Okay.
His disqualification issue is pending for the tribunal.
So what to do? Should we?
Your Lordship can dispose of that.
Your Lordship, another chance may be given to frame my arguments accordingly. On next, because Your Lordship, another fact is that this honorable court has time and again held the.
We will give on the next date, fixing on Friday next. Only this, you will get only 15 minutes time.
Yes, Your Lordship.
Right. Next on Friday. And the request of Mr. Priya, will be here on council, appearing to the appellant. Responding, but I am telling you, you yourself is entangled in a very kind of a snare. I do not know how we'll come out of it. I was all through just observing what you are interacting with Justice Sahu. You start the journey with there are 1983 Supreme Court regarding the unbeaten scope of the 226, which also compared with the jurisdiction of 226. Then you come to the Shurjo Devra, how it opened, why the question was referred to the bench, what was the crux of this controversy, then how it has been decided in Radhesham. Then Radhesham is veto followed in the next case.
They have just simply
extracted and says and reasserted the things that it cannot be allowed to be in this fashion. And you argued one extreme point on that day. You are also not today raising that point. Even under Article 227, in some cases, writ appeal will lie.
That was happening today a little bit mellowed. And it out that it is 226.
The law is very settled in this matter. If you go some here and there, Madhya Pradesh and other things, some judgment you will find. They have not applied this principle. They have decided, since we have the power, we can also allow the appeal. There is also a root issue. Suppose in a writ of certiorari issued under Article 226, this intercourt appeal will lie. Right? A writ issue under Article 227 against a court's order, intercourt appeal will not lie. So what is the dividing analogy? It is a root is the certiorari. So you have to apply this. If you would like to take more time, you can provide you more time. But otherwise, it is a just 5-second matter. Because I will just dictate 5 lines, but it will end there.
Well, Lordship, I'll prepare accordingly. I'll at least I'll make an endeavor to make a good case out of this, Your Lordship. Try to make a good solution.
I am saying that you argue on the basis of the development of the law. If you even do not get the case, that may settle certain this area which is grey in nature, that will be settled. That will be your satisfaction in that area. You may not get it. Yes, right? All right. When do you want?
Joginder Singh did different views taken than Joginder Singh, then he may have a case.
No, in the last occasion, he was trying to between what is the distinction between the tribunal.
So that never struck me. So that's a question, that is arguable part. But till now, there is no an evolution.
When do you want it?
Your Lordship, any day next week.
Next week there is no space. Next week another two holidays are there.
Then Your Lordship, last week of September. Otherwise October, Your Lordship, as per the convenience of Your Lordship.
No, fix on 9th of October, fixing it. 9th of October, the request of Mr. S.S. BL and Council of the Appellant. Ms. D. Mahapatra and Council appeals for the respondent.
His application for amendment, Your Lordship may allow. He is not submitted.
It is not before us.
Not.
That is.
I'll file it.
Yes, Your Lordship. I'll file it in the registry. I have it right now, but I'll file it in the registry. Item number 2.
Item number 2, my lord.
Yes.
So, Lord, order passed by the Lord and single judge and challenge, my lord. What has happened in this case, my lord, brief facts is the Orissa Public Service Commission issued an advertisement way back in the year 2012 and 13.
Yes.
For the post of assistant section officer, my lord. The respondent applied for the said post under 2 categories: spokesperson, ex-serviceman category. Because he has taken prevaricating stand in all his application forms, so therefore he was not being considered. But challenging that non-consideration, he came before the Honorable Odisha Administrative Tribunal way back in the year 2016. 2016 only notice was sent and there was no interim order. From 2016 to 2022, my lord, the matter could not be taken there in the Administrative Tribunal because tribunal got abolished. And 2021, all these matters got, my lord, transferred here. And 2022, my lord, the matter came before this Honorable Court. Lords may kindly see page 6. I have quoted that order. That is order number 1. Wherein it has been written, Mr. J. Patnaik, Lord and Government Advocate, 6 sometimes to file the counter affidavit.
Then thereafter, my lord, on 9/3/2023, OPSC was sent a notice, my lord. First time issue fresh notice to the OPSC by special messenger. Thereafter, the matter was listed to 27/3/2023, my lord.
Yes.
And when the matter was taken up on 10th April 2023, there was a, my lord, prayer made before the learning single judge. They grant us some time, we'll be able to file a counter affidavit. Learning single judge, my lord, did not give us a reasonable opportunity, my lord, and passed the order. My lord, may kindly come to page 69.
Yes.
I'll read out, my lord, page 69.
Yes.
Having heard learned counsel for the parties and taking into account the materials available on the court and the fact that the petitioner has submitted an affidavit as required in terms of annexes 3 and 4 before opposite part number 2, this court directs opposite part number 2 to take appropriate steps by recommending his name to the government, opposite part number 1. Such recommendation shall be made by the opposite part number 2 within a period of 1 month from the date of receipt of the order. Now, Lordship may kindly see his application. Page 23 may kindly be seen, my lord. The Lordship may kindly see page 23.
Yes.
Now there is a column, my lord, called 7A, 7B.
Yes.
Just after the fixing the photograph, my lord, that is that ex-serviceman 27 September to 27 September 2024.
Yes.
Your lordship got it? Now, lordship may kindly come to page 31, his discharge certificate, my lord.
You want in the writ petition or the?
Yes, yes, writ petition.
Okay.
I have given that writ petition. I have given that copy of the writ petition is also annexed.
No, you are placing the writ appeal or the petition?
Writ appeal, page 31. Your lordship, page 31. Lordship may kindly see date of discharge.
Yes.
Date of discharge, the column 2, my lord. He says that 30th September 2024. The lordship may kindly come to.
Yes.
My lord. And lordship may kindly come to his original application. He takes another stand. Original application, he says he was discharged on 20th 9. Lordship may kindly come to page 17.
70?
117, my lord. I'm sorry. 17. Of the writ appeal, my lord. Paragraph 6.2, my lord.
Higher qualification, that is it.
Page 17.
Oh.
6.2, my lord.
Is a part of writ petition.
Yes, it's part of the writ petition. He gives another date, my lord, that he was discharged from duties on 20th 9.
Paragraph 6.2.
6.2, my lord. He could not bring to the learning single judge notice, my lord. We wanted to file a counter affidavit.
Yes.
So therefore, the matter was disposed of, my lord, and directing us to recommend the person's name for appointment, my lord.
You are banking on the date of his discharge.
Yes, my lord. Just bringing to a lordship's notice in 3 places. In the writ application, he has made 3 averments. We could not file our counter affidavit because, my lord, on the day the learning counsel for the OPSC appeared and praised for time, learning single judge, my lord, has relied upon all the averments made by the petitioner and passed the impugned order, my lord.
So we are admitting the appeal.
Yes, well, Your lordship may repeat, ma'am. Yes. Yes, ma'am.
But Mr. B.P. Tripathi, learned counsel appearing of the appellant by means of this intercourt appeal, the order dated 19/4/2023 passed in WPC OAC number 3197 of 2016 by the learned single judge has been challenged. Mr. Tripathi learned counsel has pointed out that adequate opportunity was not granted to the appellant for filing the counter affidavit. That apart, and single judge was also not referred to the certain so therefore, when passing the order, learned single judge did not take notice of certain relevant facts relating to the qualification of the respondent number 1. Stop. By the impugned order, respondent number, the appellant has been directed to recommend the name of the respondent number 1 for the post of
Assistant Section Officer Group B, madam.
Assistant Section Officer
Group B.
Group B.
Yes, ma'am.
Group B within a period of 1 month from the date of receipt of the order. In paragraph 4 of the impugned order, it has been observed that the notice was served on the appellant by special messenger on 9/3/2023, and in spite of due service of notice, when nobody appeared on behalf of the appellant, the matter was adjourned to 10th April 2023 in terms of the order dated 27/3/2023. So, Mr. Tripathi learned counsel has submitted that when the matter was taken up on 10th April 10/4/2023, a prayer was made before the learned single judge for adjournment so that the appellants, being the opposite party in the writ proceeding, could file their counter affidavit. The said prayer was rejected. Admit the appeal to be heard on merit, issue notice. The notice is made available on October 19th, 2023. Steps with service on the respondent shall be taken. On the respondent number 1 shall be taken by the appellant by registered post with AD within 3 working days from today. Mr. M.K. Kuntia, learned counsel, appears in words notice for the respondent number 2, and hence no formal notices called for. Go to this IA. You have not filed the certified copy? You have not filed the certified copy?
My lord, the
This one should be finalized. First,
My lord, we have filed an application for dispensing with the certificate copy. We have filed an application for dispensing with the certificate copy.
you file this certified copy.
Immediately, my lord.
Just first order. After the order, I number 2774 of 2020. There's an application for dispensing with the filing of the certified copy and preferring the intercourt appeal against the order dated 19/4/2023. In WPC OAC number 3196 of 2016. Mr. BP Tripathi and Counsel appearing for the petitioner has stated that considering the urgency in the matter, the appeal has been filed with a downloaded copy of the order. Stop. He has also undertaken that the certified copy of the order will be submitted immediately after it's received from this court. Stop. We do not find it a difficulty to dispense with the filing of the certificate copy with the memorandum of appeal as a downloaded copy of the said order has been filed. However, the appellant shall file their certified copy within a period of 30 days from today. So, according to these applications is disposed of. Now go to the end. I number 275 of 2023. This is an application for staying the operation of the order dated 19/4/2007. So since we have admitted this appeal to be heard on merit, we are of the view that we should consider a prayer for staying the operation of the said order, issue notice returnable on the same date. Steps for service be taken by the appellant applicant within 3 working days by established with AD or service on only report number 1. Since Mr. Notice for the report number 2. No formal notice is called for. Meanwhile, the operation of the impugn order dated 19/4/2023 shall remain suspended.
Deeply grateful, my lord.
Item number 3.
Wait, please. In item number 3, there is a writ appeal against a election petition. In the meantime, election case matter already been disposed of, and the judgment has already been delivered. So the lordship may pass this.
Here, Mr. Kaur.
Yes,
Mr. Shubhendu Kaur, and counsel appearing for the appellant, has stated that by influx of time, this writ appeal has become infructuous. Accordingly, the resolution stands dismissed as infructuous. Who is appearing? For the other side, no, none. Okay.
Item number 4. Please, your lordships. Lord, here is a case where the Honorable Single Judge, while allowing the writ petition of a debtor or a guarantor to a corporate debtor, has held that the provisions of appeal under the IBC will not be applicable because Part 2 doesn't permit for any appeal. That is the number 1 issue. Then the limitation has to be because the 2019 rules came where the corporate guarantors, individual guarantors can also be proceeded under the IBC. So, but the Honorable Single Judge has held that the limitation start from 2015 when the loan became NPA. So, all those which were pending, that means the creditors cannot proceed against the corporate guarantors, not debtors, corporate guarantors in individual capacity. And the third issue, which is also paramount here, my lords,
the Honorable Single Judge has held that 16B, the power of the President of NCLT to transfer the matters from one tribunal to another has not been exercised, and the notification of the government for creating the NCLT at Qatar cannot be given effect to unless the President permits the transfer of a particular case from one tribunal to the other. It is like once bifurcation comes in a particular state, and the central government issues that all the matters will be released, that it will go to the second state, or so far as the jurisdiction is concerned. The Honorable Single Judge means to say that in every case, the CJI has to pass an order to that effect that it has to be transferred. So these are the major issues on which I challenge. I'll just take your lordships to page 41 of the rate appeal, which is the finding of the Honorable Single Judge. Because I've framed the issues in the synopsis also, as well as in my appeal menu in the first page itself. Your lordships? Yes. Yes. Lord, there is the section 95 under which the corporate individual guarantor can be proceeded. I'll just take your lordships to the provision, my lord, first. Then I'll come to that order. That is section 95. IBC code. Yes, this is under chapter 3, if your lordships would see. Application by creditor to initiate insolvency resolution process. A creditor may apply either by himself or jointly with other creditors or through a resolution professional to the adjudicating authority for initiating an insolvency resolution process under this section by submitting an application. A creditor may apply under subsection 1 in relation to any partnership debt owed to him for initiating an insolvency resolution process against any one or more partners of the firm or the firm. Then where an application has been made against one partner in a firm, any other application against another partner in the same firm shall be presented in or transferred to the adjudicating authority in which the first mentioned application is pending for adjudication, so and so, my lords. So this application was filed, and the initial proceeding was initiated by one of the creditors, which is IDFC in Mumbai, under section 7 in 2017, my lords. So when the matter was transferred here, then under the rules of 2019, which is, my lord, if your lordships would see the rules of 2019, I'll just since I had marked in that other book, my lord, the paging is, I'm sorry, my lords.
This is your book?
Yes, yes, yes.
So take the book. Yes. Use the book.
If it is, my lord, lordships may see if it is the edition of
Insolvency and bankruptcy application to adjudicating authority rules.
2019.
Guarantors to the personal guarantor. Then you are referring to which? That the form within the statute of 7.
They say this 16.
Individual. So, your lordships may come to section 7.
Yes.
In rule 7. I'm sorry, my lord, rule 7. Application by creditor. Application by creditor. A demand notice under clause B of subsection 4 of section 95
what I was reading, my lord, I'll just take back your lordships to that after this. Shall be served on guarantor demanding payment of the default amount in Form B. Earlier, my lord, there was no provision that against individual directors, the creditors can approach the IBC or the company law tribunal. So this was, for the first time, it was brought in by virtue of these rules to be read into Section 95. And this was done in 2019 December. So in terms of this, we filed the application, which is a completely different proceeding than the Section 7 proceeding, which has been initiated by another creditor. But it was based on the NCLT clubbed matters. That we'll hear because there are two creditors. One is against the corporate guarantor, one is against the corporate debtor. So those were clubbed. While challenging the proceeding or the application which has been made by me before this honorable court, before the honorable single bench, the honorable single bench said that the transfer of that original application of Section 7 is bad in law because the Section 16B was not complied. And since these both the matters were taken up together, this also fails. So the entire proceeding has been caused by the honorable single judge. So in the process, what happens, my lord, since 16B was brought into operation by the honorable single judge under the rules, I will just take your lordships to Section 16. I'm sorry, rule, lord, that is Section 16 of the Rule 16. Rules, sorry, NCLT Rules 2016, Rule 16. May I read, my lords?
NCLT is not available in any.
NCLT Rules 2016. If your lordships, once I can give one, another copy of the book, so. Your lordships may have a look at the provision. What I've given them. National Company Law Tribunal Rules, Section 16. Functions of the President. In addition to the general powers provided in the Act and in these rules, the President shall exercise following powers, namely, so and so. D is the issue, my lord, here. Transfer any case from one bench to other bench when the circumstances so warrant. So there will be an application under any particular or any emergent circumstance where a party makes an application. Under this provision, then it has to be considered by the President. But here on creation of NCLT Cuttack, when all the matters which were pending so far as the jurisdiction was concerned regarding Chhattisgarh, before the NCLT Bombay, got conferred on Cuttack by virtue of the notification issued by the Ministry of Corporate Affairs. But that has been struck down. Even that transfer relating to the original case of that Section 7, which was transferred by the Honorable Single Judge, while adjudicating my application, which was against the corporate guarantor. So now what the cascading effect will be, all those proceedings which have been transferred, which relates back to the date of the transfer, or which have been filed after the creation of the NCLT bench in Cuttack, that will have no problem. But so far as all the matters that were transferred automatically by virtue of the notification, now will automatically stand terminated before this bench. And in the present case, the due which is from the corporate debtor is in excess of 800 crores, out of which my loan credit amount is about 490 crores.
Other banks are there.
And other financial organizations, the banks, NBFCs, everybody has extended their loans to the company.
But whether there is any provision of transfer, an express provision of transfer is there, except this 16?
No, my lords. Absolutely not. And in the corporate affairs, that notification of 2017, I'm sorry, 2018, I'll just, that I mentioned the date in my date chart, but because, yes,
Can you see the notification by which the transfer comes?
yes, my lord, I'll just,
There
was 1st of June 2016. I'm sorry, my lord, the subsequent one is 2008, yes. This was part of the counter which was filed before the NCLT by Union of India. It's a very small notification, your lordship may see.
It is the establishment of the
establishment, my lord.
Yes.
And then because the jurisdiction was also given so far as the state of Odisha and state of Chhattisgarh.
Yes.
So earlier the state of Chhattisgarh's jurisdiction was under the NCLT Mumbai.
Right to it.
So if all the matters were automatically transferred to NCLT Cuttack because of the change of jurisdiction and creation of the forum.
But what is the transfer notification?
Well, that is, I don't think that has been filed by the Union of India. This 2016 notification is only with regard to the coming into effect of the Act and the creation of different new NCLT benches and their jurisdictions. If your lordships would see page 16, the previous page.
Yes.
The Mumbai bench had the jurisdiction so far as Chhattisgarh is concerned.
We understand that. Problem is that now, when this tribunal was constituted, it was a common tribunal for two states, right?
Yes.
Chhattisgarh and Maharashtra. Now it has been changed
to Chhattisgarh and Orissa.
Establishment of the Court of Tribunal. They says it is Chhattisgarh and Orissa. So from the Mumbai tribunal, that you have to transfer the matter. Where is the provision to transfer except 16? Says that it is.
That is 16 is regarding, my lord. It is. I'll just read out again if your lordships are. That is transfer any case from one bench to another bench when the circumstances so warrant.
Mr. Nanda, lordship's queries is
whether there is any specific notification regarding transfer of cases.
Because what you are saying is jurisdiction. Jurisdiction was changed, the territorial jurisdiction was changed.
Yes.
But what is the provision that it would be transferred?
Yes, that whether like pending cases will be transferred or not.
What that power is required.
Yes, my lord. And that is by the central government, which has been done. I'll my lord, if your lordships.
Where is that provision that the central government do it? Here it says, in addition to the general powers provided in the Act, and in the role the president shall exercise the following power.
Yes.
The first one is not a performance annual report. Transfer any case from one bench to other bench when the circumstances so warrant. So this is the relevant provision 16D. But where is the notification under section 16D?
Look, 16D was not there because these were all transferred automatically and by virtue of the notification by the central government. But so far as the transfer of the pending bills or pending matters before the particular tribunal from Bombay to Cuttack, I'll my lord find out if your lordships would grant me a day's time.
Because this transitional act, because they're changing things, everywhere there you will find a express provision how the things will take place. Suppose I give you one example from the Family Courts Act.
Yes.
A similar situation arose because earlier it was the domain of the district judge.
Special court.
But there is this express provision from the day of establishment of the family court in the particular territorial jurisdiction, all the matters pending in district courts or any other courts, meaning the civil criminal court also, that will stand transfer automatically to that court.
So whether such a notification,
Revise this, yes.
so whether there's such a general notification, I'll try to find out, my lords. If the lordships can keep it to Friday.
Not this Friday.
Yes, or anyway, subject to your lordship's convenience. Only to that limited extent, I'll just try to find out.
September. List on 21st of September, the request has to be among and council appearing, senior council appearing to the appellant. Because this is actually, he was troubled with, there is no provision, how can that be done, is the president issues the notification.
Yes.
To look into it, yes.
And the other aspect also, that is a different issue so far as this is regarding the jurisdiction limitation, and the third is regarding that no appellate provision is there. Because chapter 2, the appeal provision is under the chapter 2, and in chapter 3, the section 95 application is made. So whether that will be made applicable, or when it says that only to this chapter, whether any order passed by in the application is applicable or not. Because the Honorable Single Judge has held that no, there is no appeal provision against this. So section 61 will not apply to an application made under section 95. So these are the three issues primarily, my lords. Lordships of fixed to 21st. Item number 5.
May I please, Your Lordship? It is regarding the selection of master bookkeeper from auditor, that is Lordship Tilachanpur Gram Panchayat has invited application on 15/7/2021 for selection of master bookkeeper, and the last date of the submission of application form was 30/7/2021. That the candidate must be a woman candidate and preferably from a self-help group member, must be a matriculate, and other conditions are there. And the petitioner has submitted all his documents along with his application form. That the opposite party or filed, the respondent filed, he has not submitted any documents along with his application form. It is an incomplete application, and his candidature should be rejected outright. But she was allowed to participate in the selection process. Thereafter, the selection process was started on 29, that is 29/4/2022. That according to the guideline that is given under Annexure 3 to the writ petition, that is Lordship turn to page 42, selection procedure is to be held up according to written test and viavas. But the selection was made without conducting written test. Only viavas test was conducted.
Come to the advertisement.
And the opposite party number 5 was selected awarding 5 marks. That the Lordship is returned to page 49. Written test.
Lordship asked you to come to the advertisement.
Lordship,
advertisement.
I am unable to follow.
Employment notice that has been published inviting the application.
No, advertisement is not there. That is there in the office board, notice board of the Panchayat.
Okay. Whatever it may be, so what it required.
Yes.
I mean, it may be in any form, in the notice board, in the paper, or it may be the Samachar, whatever. But so, what was the requirement as required in that employment notification?
Lordship may see the eligibility criteria. Lordship may turn to page 41 of the writ petition.
If my Lord Senior is referring to the writ petition, then he should have supplied a copy to me.
I will provide.
Read petition copy I will provide.
From your office, if you can find out, he will provide also. If it is not consent to the record room, then in fact, that is difficult for him also. He is not having that copy.
Annexure 5 is the evaluation sheet.
Here the learned single judge quashed the appointment of opposite party number 5. But direction was not given to the appointment of the petitioner. That is the question. Let's turn to page 22 of the writ appeal. Para 5.
Petitioner's name is?
Petitioner name is Sanjivata Ghade.
I saw it. I've seen it. Just translate it.
Petitioner has experience, Lordship may see, she has experience in self-help good 2 years. She is already, she applicant before the learned single bench. Yes. So she has got 0 in 3. No. She has received 2 marks. 0 in 3 per 3 evaluators or 3 evaluations. Yes. Sanjivata Ghade, item number 2.
Serial number 2, not item number. Serial number 2. Panel 40, panel 50.
Yes. Panel 1 and that panel 3-1. Total 2 marks.
So she has got 3 zeros and 2 ones.
Yes.
So how do you say that she should get?
Naturally, she was entitled to get 3 marks from experience certificate. And Lordship turn to page 49 of the writ petition.
No, where is that? Where is your contents on that?
Page 49 of the writ petition.
So as far as the evaluation is concerned, concerned, where is that column? Where is that column for experience?
That is experience column is Lordship see page 49. That is 1, 2, 3, 4, 5.
That is another page.
Read petition page.
Sir, read petition I am but your Panchayat Mahasangha द्वारा होइथिबा मूल्यांकन that translates to that they are not evaluation by the Panchayat Mahasangha.
Yes, that they have only, that is the evaluation of viables. They have not evaluated other marks. That means they have not awarded that 3 marks for experience, 5 marks for 3 marks for scheduled caste candidate.
Other marks, no, where you are getting these marks, I am unable to find.
That marks are not given. By
then where is the stipulation that you will get those marks?
That is under page 49 of the writ petition.
49.
Yes. Column 3, that is scheduled caste and scheduled types, minority 3 marks. Experience 3 marks, 1 to 2 years.
What is this document? Who created this document? Who created this document? What marks, how that will be given?
This is the guidelines of the master bookkeeper come auditor's guideline. Who issued that guideline? That is issued by the Odisha Livelihood Mission. Page 38, Annex 3.
Is 38. Yes. Okay. Is it Muduli, are you appearing here?
Here, the Honorable Single Judge came to a conclusion that though the requirement as per the guideline is for conducting the written test as well as viva test.
He says no written test was there.
So the parameter, the principle has to be applied to all the candidates. Now on this ground only, since there was no written test, on this ground only, the appointment of the respondent number 5 has been set aside. So the petitioner stands at similar footing with that of the respondent number 5.
No, to that query, he answered that I have appeared at the, you are showing some page that I was trying to ask him actually.
No.
Mr. Mishra, you have not appeared in any test when you said that is at 49 or 48.
My lord, may kindly see each question which has been framed, page 6.
49, apart from interview, you have also not appeared at any test. That is the contention raised by the Lord DG.
Only that is the test they have conducted, that the selection committee.
Then when you were asked, you were saying that is in another page, you are referring to some other page. You should have said that, yes, I have not also appeared in any examination.
No, I have not appeared in the written test.
So you have only attended viva?
Only.
5 has only attended viva.
Yes.
That is the only evaluation.
Only evaluation and other marks that is to be given under the experience and schedule caste candidate, that was not given.
Guidelines that you get this mark, you are not getting this.
Then on your own showing, the entire selection process is vitiated.
Yes,
that's the honorable single judge has given that finding only.
Otherwise, the opposite party number 5 should not be allowed to appear because his candidature should have been rejected outright.
I could not follow actually. What opposite party number 5 should not have been allowed to appear.
Yes. He has not submitted any document. That is incomplete document.
Her selection has been set aside. What is the point in this court entertaining or thinking that he should be allowed or not? The entire thing has been set aside. At your instance, of course.
Of course, I have appeared in the test that I should be.
No, not test. Again, you are using that word test. You have stated that you did not appear at any test. Only that viva was conducted where you have got 3 zeros and 2 persons have given you 1 mark each, and she has got total 5 marks. So if her appointment or selection is to be set aside, then your appointment also goes, because that the basis is that there is no written test as per that MBK guideline. The guideline you have just placed page 38 issued by the department, master bookkeeper cum auditor, Panchayat Odisha Livelihood Mission, Panchayati Raj Department, Annex 3.
Yes, that is
so that prescribes a written test.
Yes, that
so in fact you have placed that also.
But for all they have conducted only viva. So the criteria.
So what happened thereafter? After setting this aside, OP number 5 has not challenged that. You are an applicant. So if all of you participate, you participate. If at all they are advertising it or there is a fresh selection process, you participate.
Who will conduct the examination?
That is interview is conducted by the Gram Panchayat level federation.
As per the guideline, who is that authority?
I don't have the copy of the guideline.
He is not actually having that read copy.
That is the appointment order was given under Annexure 6 to the writ petition. That is a Trilochanpur Gram Panchayat Rajya Panchayat Stadiya Sangh. Lordship, you see page 54 of the read petition.
Respondent number 4. Respondent number 4. Trilochanapur Gram Panchayat level federation.
Sir, page says selection of MBK is the primary responsibility of GPLF. Page 42.
Page 54. What is GPLF, Mr. Mishra? That is a Gram Panchayat level federation. That has been selected, Lordship, you see annexer 6, page 54.
No, your contention is that since you have secured 2 marks and her selection has been set aside, you will be selected.
Yes.
How can that be? The finding is that no.
If the candidate is outright rejected, then I will be the only candidate.
No, both of you are in the same boat and the boat has sunk. So it can't be that for her you will say that yes, no test is to be then the read court, the appellate court has to give a finding that written test is not necessary.
No, written test they have not conducted.
They have not conducted is one part. That is how the entire procedure has been struck down. Just read it aloud, your page 42, because he is not having that. Just read it aloud, page 42, para 6.
Selection procedure.
The selection of MBK. Yes.
Yes, selection of MBK is the primary responsibility of the GPLF. All such interested candidates will be assessed through.
Candidates will be assessed. That portion is important, slowly. Through aptitude and attitude tests.
Yes.
A merit list will be prepared for those who have secured the minimum qualifying marks more than or equal to 50% in written test, objective and subjective. Subjective.
Yes.
Bracket close. Considering total secured marks, written test, well-being group of SC/ST minority, plus including disability factor, plus interview. So till interview, nothing is there.
No.
Written how you are saying that? They have not conducted any tests.
There is no responsibility law. Who participate in this selection process? When there was no process involved. Yeah, Mr. Pradhan.
Mishra.
Appellant counsel. Appearing for the appellant also heard Mr. Muduli, learned P.K. Muduli, learned counsel, appearing for the
1 and 2.
Respondents number 1 and 2. By means of the High Court appeal, the appellant has challenged the order dated 9/8/2023, passed by the single judge in WPC number 24730 of 2022. The appellant was the writ petitioner. And he had challenged the appointment of the opposite party number 5. Respondent number 5 in this appeal. In the post of master bookkeeper by the order dated 1st May 2022, Annexure 6 to the writ petition. So, the case of the petitioner in brief is that the employment notification was only posted on the notice board so Mr. Mishra Council has submitted that for purpose of selection, a guidelines has been issued by the Orissa Livelihood Mission titled as Guidelines for Master Bookkeeper cum Auditor within bracket MBK. Said guidelines provides the eligibility criteria of MBK, the order of preference for shortlisting MBK, and the selection process. So where the selection process is concerned, it is the primary selection is concerned, it is the primary responsibility of Gram Panchayat level F for federation. So it has been provided that all the interested candidates will be assessed through aptitude and attitude test. A merit list will be prepared for those who have secured the minimum qualifying marks clause within first bracket, more than or equal 50% close the bracket in written test, start bracket, objective and subjective, close the bracket, considering total secured marks. Within bracket, written test plus well-being group or ST/SC / minority as may be the case. The case may be grouping or STSC / minority as the case may be, plus including disability factor, plus interview, plus Shakti Shohika or working for the concerned GPL experience. The person who will secure the highest mark will be selected for the post of NDK. In case of equal marks secured by the candidates, the priorities will be given to the persons having disability within bracket PWD, EPVG / tribal, scheduled caste / minority, daughters / son of SHG member, age, life experience will be given reference, etc. Let a single judge, having scrutinized the records, particularly the interview evaluation sheet, has come to the conclusion that that there is no dispute regarding omission to conduct a written test in the recruitment under the old guidelines, resulting in appointment of the opposite party number 5. In these circumstances, the appointment of opposite party numbers 5 was set aside. It has been directed further that the state, through the concerned functionary, shall proceed to issue notice for making the appointment. So it has been also observed that the recruitment process will be expeditiously conducted. Stop. All eligible candidates who will respond for appointment shall be given the opportunity to participate in the selection test. Stop. Mr. Mistral and counsel has submitted that, except the appellant, no one had the requisite qualification, and as such, he should be appointed straight away. We are unable to accept this analogy in as much as the laid down procedure for selection has not been followed. Stop. The Gram Panchayat level federation, GPLF, had responsibility to ensure that selection is made following the guidelines. Stop. As such, we do not find any infirmity in the order of the learned single judge. Accordingly, the same stance affirmed. Consequentially, the writ appeal is dismissed. There shall be no orders to cost. Before that, P.K. Muduli has declared for such exertion. Government.
Item number 6.
May I please your lordship? Pilot.
Yes.
Your lordship was pleased to allow me to mention the matter, and on mention your lordship was pleased to direct my learned senior to take instruction regarding the matter. Opposite party number 3 is going to make drain upon a narrow road that is below 10 feet.
Anyone is there for the state here?
From the given segment of the BLC. In given segment, the Commissioner of Municipal Corporation.
Notices to you.
Separate council.
All right.
They have proposal. They have proposal to make drain that is 344 feet. In the meantime, they have acquired 234 feet of land. Width is 5 feet and length is 334. 234 they have acquired. Thereafter, they are going to drain the drain upon the narrow road. And there are several vacant lands out there. In the vision of the long-term vision, they have to invest the public money in the proper manner. But on which
already you are simply issuing notice because this is a highly technical issue. We do not know anything of that. Heard Mr. K. Pradhan Learned Counsel appearing for the petitioner. By means of this public interest litigation, the petitioner has asked this court to restrain the construction of drain upon the narrow road which is situated
situated at Khata number 738.
Situated in Khata number 738, plot number 1237/1461.
Under Rajarani Moja.
Under Rajarani Moja, ward number 58, Bhubaneswar, 36. Stuff. Issue notice returnable on 11th of October 2023. Since Mr. P.K. Muduli, M.K. Kuntia, learned additional government advocate, appears and waives notice for opposite parties number 1 and 2. No formal notices called for. While the petitioner shall take steps for service on the opposite party number 3 by registered post with AD within 3 working days of life.
Item number 7.
Lord, it is a case regarding using the railway level crossing for last 50 years. When the railway authorities, my lord, took the decision to close this down on our petition, Annexure 9, the collector, after conducting detailed inquiry through the, my lord, field functionaries, including sub-collector, page 33, recommended to the divisional railway manager Kharagpur, my lord, in our favor. I am reading, my lord, regarding reopening of gate number level crossing 57 situated at National Highway 18 near Budhamara railway station. Inviting reference to the subject cited, I am saying that on the petition filed by villagers, my lord, so and so, the field inquiry was entrusted to the sub-collector Baripada, who conducted the inquiry along with SDPO Baripada, IIC Bangirpusi, RI so and so, in presence of the villagers of the above mentioned villages. The sub-collector Baripada interacted with the villagers on various issues faced by them and suggested for a reopening of the level crossing gate number 57 situated at National Highway 18 near Budhamara station. In view of the above, I am to request you necessary steps be taken to reopen the gate number level crossing 57 near Budhamara railway station, and the action taken report may please be sent to the undersigned for record and reference. Well, this recommendation dated 5/8/2023 addressed to the divisional railway manager Kharagpur, without any also acceding to the prayer, the advertisement is issued, my lord.
Yes, Mr. Mohanty, are you correctly made them the party? This railway, which railway is involved in this matter?
My lord, Southeastern, my lord. So, OP number.
My lord, Lordship may see for a moment page 26. page 26 may repeat the relevant paragraph 2. That is a report of finding of the inquiry of the block BDU, block development officer Bangiripusi,
Yes.
who mentioned that visited the alleged site on 7/3/2000.
So, Badi, my lordship's query was whether Southeastern Railway is operating in Odisha or East Coast Railway?
No, it is coming on Southeastern Railway, East Coast Railway after Bhadrak.
Okay.
From Bhadrak,
So it is Southeastern, that's correct. Okay, Garden Reach and Kharagpur division.
Yes, my lord. So my lord, annexure 11, page 37. My lord, ignoring the recommendation of the collector, my lord, DRM has issued a notice, page 37, my lord, translated copy, notified that following manhandled level crossing existed in the Rupsa Bangiripusi rail station will permanently be closed with effect from 15/9/2023. So our level crossing against rail number 357, Rupsa Bangiripusi. So it is going to be closed down by 15/9/2023, my lord. So it has been used for last 50 to 60 years, my lord. When the narrow gauge line was there, now it is expanded to broad gauge. So the students, patients, connectivity to national highway, and but all other accessibility and road connectivity, we are doing these are all used by us. My lord. 8 to perhaps 1 block, entire, my lord, 5 to 6 Gram Panchayat people.
Is Mr. Pari, what can be done? You are on mute.
Sorry, my lord. May I audible, man?
Yes.
My lord, in that page 26 of the report of the video, LRCMC, for a moment, they visited the LS site of 7/3/2022 and inquiry was conducted in presence of the petitioner Sri Pani and some other local people. During inquiry, it was verified that earlier, before opening of the Ford Overbridge FOB, the railway crossing passed through the NH18 was being used by the villagers, mostly of the village of such and such station, such and such. On the Sital Dhara and such and such for their daily convenient connectively to both sides of the NH and railway tracks. So there was a foot overbridge FOB.
So, Mr. Padi, no, it's not that. He's referring that it is the report is in his favor. Page 27.
Yes.
So they have to negotiate 3 kilometers extra. That he is acting on. In fact, he is also relying on that, what you are reading.
Yes, their recommendation
Para 5
needs to be open as well as earlier and view of the limited rail traffic chain. They have said so. If Lordship want, then I have taken instruction. Because
3 kilometers is quite a long distance, Mr. Padi.
Because annexure 3 series page 7, it was written in Odia.
Counsel appearing for the petitioner by means of the public interest litigation, petitioner urges this court to direct the divisional railway manager, Southeast Railway, Kharagpur, not to close the level crossing 57 as that would cause serious difficulty for the local people. In this regard, the notice dated 29th August 2023 as published in the various newspaper has been referred. So, 2 reports are available with the writ petition. One by the block development officer Bangiripusi Bangi Poshi. Bangi Poshi. And the other
Page 33, collector.
Annexure 9. Yes.
by the collector and the district magistrate Mayurbhanj, Annexure 9 to the writ petition. Both the reports have strongly recommended for continuance of the said level crossing in the interest of the people. Stop. Issue notice since Mr. P.K. Pari, Learned Deputy Solicitor General of India, appears and web notice for the opposite party's number
1 to 4.
1 to 4. No formal notice is called for. Mr. P.K. Muduli, Learned Counsel, appears and web notice for the opposite parties number 3, 6, and 7.
5, 6.
5, 6, and 7. Let the matter be listed on 11th October 2023. In the meanwhile, the said level crossing 57 shall not be closed and the people are allowed to use it for crossing the railway line. Following the standard, following the restrictions, that's all that will do. All right.
That's right. Item 8.
Lordship may reflect along with Mr. S.S. Kashyap appearing. Obliged.
Item number 8. Two ayes are there. Two interim applications are there.
Okay.
One for condonation of delay and another for dispensing with filing of certified copy. My learned friend has already appeared. If he has no objection for condonation of delay, that
No, I have objection.
he cannot file any objection.
There are 321 days delay.
In file objection.
I have not filed, but registrar has pointed out the 321 days delay.
No, file the application because unless
I'll file that.
So far as dispensing with petition is concerned, your lordship may give some more time so that I can file that certified copy.
which one is this condonation petition?
The dispensing petition, madam, that is okay. 1256, madam, flag C.
Yes. First, you take 1256 of 2023. Is an application for dispensing with the filing of the certified copy of the order dated 28th March 2022, passed in WPC OA number 3240 of 2013. Stop. Mr. P.K. Mudali and counsel has appeared for the appellant and stated that for urgency, the certificate copy could not be obtained and the appeal has been filed with a downloaded copy. Stop. We do not find any difficulty to dispense with the filing of the certified copy of the said order dated 28/3/2022, but subject to condition that the applicant shall file the certified copy within a period of 15 days from today.
No.
Stop. Next, this is an application. This is a 1254 of 2023 for condoning the delay of 321 days in filing the intercourt appeal from the order dated 28/3/2022 passed by the learned single judge in WPC number 3240 of 2013. Stop. Issue notice as to why the said delay shall not be, the aforementioned delay shall not be condoned or pass any other order or orders as seen fit and proper. Stop. Notice is made returnable on 11th October 2023. Since Mr. A. Mohanty. Mr. Ranjit Mohanty, learned counsel appears and waives notice for the opposite respondent number 2. No formal notice is called for in respect of those that responded. However, the appellant shall take steps. It is a government department.
Yes, madam. The formal party, because you are the party in that way.
Appellant shall communicate the filing of this appeal to the project director, watersheds. Stop. No formal notice is also therefore called for. So Mr. Mohanty and counsel, opinion of the writ petitioner respondent is submitted that a short accommodation may be provided for filing the objection against the prayer for condemnation. Let the matter be listed.
11th October.
11th October. Saying we just repeat it or arrange it. Huh? Yes. No stay order. No stay order.
For the time. No, my lordship, I have objection, my lordship. Because the person has continued since 1993 and he is in the cause of retirement. Their stay is required in the sense, my lord, now they are not insisting for contempt, so for that reason we are saved.
Whenever the contempt is filed, you revive this application. We are not disposing it. Yes. Oh, let it rise. Other matters you please. October.
Number 9, notice on the issue of delay has been issued. They're supposed to file the objection.
Today,
what I pray, my lord, there is a delay of 222 days, my lord.
Today I am filing the objection, my lord.
Not in the court, filing the registry.
Item 12, my lord.
It will be
Very urgent 12,
21st of September. List on access and search. Meanwhile, the opposite party may file the objection. If any, no, there shall be no further accommodation. Okay, Mr. Vigyan Sharma, for the appellant applicant.
Item 12, my lord.
Only 145 days delay.
Mr. GS.
Previous occasion he appeared, my lord. So it is already there in the order.
But in cost title it has not been reflected, my lord.
Registry directed to reflect the name of Mr. GS Settle and Council, or the council of the respondent. What is it, please?
Item 10, my lord.
Other date will be provided.
Item 12, my lord. Serious.
Only 144 days delay.
Notice was issued earlier.
No, notice has not been issued. Only government is the opposite party, no private party are there. OPSC.
What about the second case? It is in item. Let the matter come some other this. There is some defect number 5D. Please remove it.
Copy not served.
Copy not served.
WA copy solved.
CNR.
The another date will be given.
Copy already solved.
Item number 12, my lord, serious urgent AL matter.
Copy solved, Lordship, there is
It is not
receipt
reaching.
of the copy already solved.
Item 12, my lord.
It will take it up on 21st. Let us see.
All order master plan.
Copy already solved, my lord.
All right, you just mention on the other day.
Let it come tomorrow or
Tomorrow is not possible.
any other day.
Give the date. Give the date.
For hearing item number 1.
Can I just take 10 minutes of your lordship?
Again, yesterday, and then reflected that you will not make any submission. Is the turn of Mr. Pradhan.
Yesterday, actually,
all right.
Mr. Khatkia actually he dissected all those medical points in the jurisprudence and medicine, medical, with regard to lungs, asphyxias, and heart attack, and also the cardiac arrest. But I just want to bring out few things, only few lines, in fact. I was going through the brief again and again, Maran. I asked myself the question, after going through the evidence of PW5 and PW19, both are doctors. PW5 is a very, very senior doctor, is a renowned doctor. He himself claims to be a renowned doctor. He visited in the first hour the house of the person, and there actually examined the patient and said that she is dead. But in normal circumstances, if he comes back and again attends the autopsy, but he could have by then and there said it's a cardiac arrest. But with the experience of that senior doctor, he could not have said that it is difficult to ascertain or have to wait for the chemical examination and visa report. But the reason being, so kindly visualize this. This is what I felt actually I'm expressing myself. Your Lordship, I just wanted to, thinking aloud for Lordship to think about it. Well, visa report can only give a limited extent of information. It doesn't refer to cardiac arrest. Chemical report also do not lead to any cardiac arrest. But if your opinion is to be given, I can understand. The doctor could have said, I have examined in the morning, I have seen the autopsy, and my opinion is, because he has not given an opinion. Kindly appreciate one thing, Willard. A senior doctor who attends the autopsy, who was present at the time of when it was done, and examined the body and everything, kept his opinion reserved. But this is unfathomable, unbelievable, in fact, with due respect.
I'm giving you a parallel example.
Right, Lord.
One of my friends recently, after suffering from fever, went to a doctor. He did not prescribe any medicine. Asked him to go for 8 tests. And the last test will take minimum 7 days. So on the 7th day, when all the report, he met the doctor. In the meantime, he's out of fever.
Recovered.
Recovered, yes.
Right.
So it is a process that we are concerned. And the process, it is very important to understand how someone has enacted interference in the process.
So that absolutely correct. I just concur with Lordship's view, Lord. What I want to say, with due respect, with the experience of a lawyer, Lord. If a client.
I'm telling you why I'm giving the story. the doctor perhaps could have given the opinion on that moment itself. But they see that the technology is available, that I send the viscera for chemical examination, then I will be. And what happened after that? At no point of time they gave any opinion. That is the situation.
Correct, Lord.
But what the trial court is possessed of, the report of the viscera. Right, there is nothing. Chemical report is completely signifying nothing.
Exactly, that's right.
Because there was no the poison, nothing of this sort.
That's all I'm saying that thing. But so to arrive at a conclusion.
Serious objection we noted that whether on the basis of their report also, whether they can state before the trial that this is our opinion now. That is the objection you are raising.
So why I'm saying, if a person first time does the postmortem, he can reserve his opinion. A person who has seen the patient or the dead body, he has seen it. He knew that the cause of death. From the very moment he has seen a person, he can definitely guess.
Universally true.
But same person actually with his experience.
First thing that he has not given any observation also that he died out of cardiac arrest. He just went there and only opinion he expressed that he's dead.
But 2 years after, can you see, he is seeing the chemical report and result report 2 years after.
No, that is that objection we have noted.
Right.
After 2 years.
2 years.
How she remembers.
Exactly.
That's because there's early reflection in their note. As Modi's jurisprudence says,
yes,
not only the report, also the notes to be produced before the trial court, how they have prepared the note, because report becomes the secondary evidence.
Well,
so, but we do not find anybody is producing the notes, the postmortem examination notes.
And he has stated in the evidence that he has gone in the morning, he has examined, he found no incriminating material, but all those things he can say. But in the morning he has visited, found the. But I remember that I have also experienced a lot of death in my family, in fact. But we know the doctor comes, immediately say, this is a question of cardiac arrest, or this is a case of this, because of the reason for which the death has occurred, and he certifies and goes away. And on that basis, actually, we proceed to cremate the body. But he is a doctor, he is a family doctor, he admits he is a family doctor. In the 364 statement, the question was put, is a family doctor? They have said yes, he's a family doctor. But the same person attends the postmortem. Same person deposed in the court. But I said the report is all right, but they have not expressed an opinion about cardiac arrest. But the statements given thereafter, with due respect for the Hippocratic oath they used to take at the time of joining the profession.
You go there.
Right.
Then I will allow to go to these states also, but you can't do cross-examination on that aspect of the matter.
No, cross-examination is done by the prosecution, in fact, and they found that he is hostile. I don't know the reason for which they have declared hostile. Only thereafter the defense takes over. And the defense has made all suggestive questions, Marat. All questions are suggestive.
They can ask leading questions. But if the doctor's view is taken away,
yes,
then supposing it is taken away, accepting for a moment, then what is there for the court to infer that it's a case of foul play?
Especially
a foul play. First of all, where is the foul play?
So the very basis is the consistent evidence of the witnesses of the relatives. We're trying to see one thing. The daughter is scared. Daughter-in-law is scared because of the threat and everything is given. Dowry demand is there. See, in different times communicated to different relations. Different times communicated. Communication is one part, but that cannot be verbatim said in the court by all the witnesses consistent in the same way. They have said consistently there was demand of dowry. They have said consistently there is a threat of bodily injury. They have consistently said she was mentally tortured. But on mentally tortured not sufficient to bring her. On the dowry demand, torture is there. That Lordship has to consider that. It is not a simple case of death, or somebody gets up in the morning and found somebody has died. It's a case 4 months. It's not that far away. And every now and then it has happened till the death.
Well, all the evidence of the witnesses, they have consistently said, well, he is trying to find out the flaw. He said this, the other side said this. So doctor must have communicated in different times. That communication to different relatives cannot be narrated in the same way. The only substance of the evidence is there is a demand of dowry, and the result is cruelty on account of demand of dowry, and the eventual result is death. But death cannot happen as such to a normal citizen. As such a healthy 22 years young lady, hale and happy, nothing has happened, and found in the morning to have died. But this must create a suspicion in the mind which might have happened. This is, one has to look into that.
Sure, yesterday observed that all these arguments will lead to a suspicion that this person can be.
So it's not a question of suspicion with due respect, my lord. I don't want.
Leave the substantive evidence.
So substantive evidence in this, the demand of dowry, the cruelty, or the torture that has been made mentally or physically, whatever that matter. Which, and there was a threat of life. She was apprehending something may happen to me if I don't fulfill it. The father assured, yes, I'm trying to fulfill it. And the news has come. She was reluctant to go back, but she has been allowed to go to the father-in-law's place when she came to the house. But we know the predicament of daughter, and the father knows what happens to the daughter, and that is anxiety. We cannot want to lose a daughter after she has been given marriage. Because I'm appealing for the informant, that's what I say. The father's anxiety is, why should I lose a father, lose a daughter who doesn't have any fault? It's because of dowry she has lost his life. And there is no element, nothing else is there. And interestingly, one thing has come out. It may not be very relevant for your lordships to consider. Can you see the evidence of PW 13? Well, kind of a look at that part.
Sadhan Jaiswal.
PW 13, at page 141. The page. So 141 minutes. He has been declared hostile, Lord.
Can you see 141 now?
He says at about 7:30 a.m., I'll go at 141. On the date of occurrence, I came to know that the deceased died. I do not know as to how she died. He's a neighbor, Lord.
Mr. Vishnu, how can you read 161?
But
161 is not a piece of evidence. And its purpose is always legally settled in section 162. What is the purpose of 161?
So 161 is to be used for the purpose of contradiction or confrontation.
161 text also will be quoted in the statement of the hostile witness also.
Right.
But there is no such initiative. So we cannot go straight away to 161.
No, I don't know. Just I wanted to bring a lot of notice.
Which is not evidence in the post-trial any hearing. You cannot refer to this evidence.
There was some.
We are not here to write fiction.
No, that's right. Correct.
Okay. So just take us to the root of evidence.
And 364 statement of all the witnesses of the accused. If you also kindly see one thing, Marat. I just wanted to bring a lot of notice. Page 79, it starts, Marat. Look at page 82. Normally, actually, when the questions are put to the accused, when they say what you want to say, they say nothing has happened. We have not committed any wrong, and it is not a case of murder. It's not a case of normal death. But kindly see what answers they have given.
Refer to the question number.
Yes, the last question that is usually put, Marat. Question number 28, Marat. that you have heard the evidence. What more have you got to say in this case? It says on 6/10/2005, we are at home. 4/10/2005, the report was against us. On 5/10/2005, report, we came to know about the report. On 6/10/2005, we went for anticipated bail to Cuttack. 8/20, we remember High Court was holiday. 21st, my wife's bail application was filed. Then 1.5 years after, it was rejected.
1.5 months.
Months, but yes, my lord. Well, then 1.5 months after it was rejected, anticipated, then 430 petition was filed. Then paraphrased again, they went to Supreme Court. But they have never said that this incident that is alleged that somebody has unnatural death or is a death, they have not stated anything. None of the witnesses, mother.
Under any obligation to state. Is the accused.
But what I'm saying, you has experience of trial also. But what I want to say, if somebody asks, what do you want to say in the case in the last question? I almost have attended Sessions Court also. But it says, no, sir, I am innocent. I am not. I did not say what you do. What I want to say, but they're silent with regard to the
burden by the prosecution by statement that
Sir, I don't want. I want to say the circumstance, the conduct of the parties. But if somebody has died, if some relative reaches, he says that she died maybe due to heart failure. But everybody absconded. Everybody absconded, man. Nobody is present at home. But they didn't say anything to what happened.
Just take the principal accused, the appellant before us.
Yes.
Have you asked this question? Why have you absconded?
Yes, but
where is the question?
The question was asked.
No, 130, 330.
The exact word absconding word is not there. But they were not there at home.
You are saying, I am talking about the evidence.
Yes, ma'am, on evidence, ma'am.
Why is that evidence? You are absconding.
I didn't see that. I didn't see that. I'm showing that.
Question number 13.
Okay.
कितने सीट है? नहीं emergency 115 115.
No, the question is that
Page 60, if you also look at paragraph 3.
Page 60. 60 is the judgment.
Paragraph 3. Paragraph 3 of the judgment.
Paragraph 3 of the judgment.
That your lordship,
His best witness to us whether he absconded or fled away from his house is the investigating officer, because he went to detain him, arrest him to take after the case was registered.
But he has also stated, my lord.
No, first thing that is the sequential you see.
Right.
He himself reported that there is a death of his wife. Then an ED case was registered by the police came to the spot. He was the person who originated the investigation.
Yes.
So it was supposed to be like ordinary, he would have left, never come back to the office. We are searching for evidence.
Right. No, that's right. But the only thing I wanted to show your lordship is that then the postmortem report, but itself cannot lead to an inference of cardiac arrest.
No, who says?
Right. No, that is exactly I wanted to do. And there is no other material to jump to a conclusion of cardiac arrest in the absence of any other material. His statement that it's a cardiac arrest after 2 years of incident in the court of law itself shows that, as your lordship said, he remembers everything in detail and he makes a statement that it's a cardiac arrest. So that emphatic statement itself.
Problem is that would have been a very good defense for you if you cross-examine the doctor. Then do you have any record you have seen cardiac arrest, you are able to return. The moment he says no, his oral testimony become unbelievable.
So the very fact, my lord, the very fact in the report, there is no such, there's a column that.
All right, but at the same time, somebody is entitled to recall his memory. We cannot stop a witness to recall his memory. Then the most of the evidence that we record, in the form of the oral, the evidence would be just out of the record. That is not there. And when you can question it, you question it that whether have you taken it or not. Because they are doctor, at least 3-4 days they are doing one postmortem. It's very difficult in what postmortem, what this, so until there is a no.
But they have mentioned that such a question was put to, if you looks at to Jojo and the doctor also, they have said we have not mentioned about the cause of death.
That is the one admission.
Right, right.
But the moment they said the cause of the death is the cardiac arrest.
Right.
Right. You had another opportunity, much better opportunity to confront that doctor. Then how can you now say at the time when you have written the report, you have not anything. Now, all of a sudden, how can you say it is a cardiac arrest?
Sir, that is
actually. Cardiac arrest cannot be asserted on the basis of the chemical report.
Exactly.
Cannot be.
Cannot be, right.
So that there should be some foundational basis to come to that inferior
conclusion, right?
But you have not put in post.
Sir, that was with due respect, my lord. Your lordship is absolutely correct. But with due respect, what I like to submit to your lordship is that from the beginning, after the witness was turned hostile, he himself has stated that we have not expressed any opinion in the report because there was no chemical examination report before us.
Then after that, you had any.
So after that, actually, the defense cross-examined.
No, you have also cross-examined. But you mean as the prosecution has also cross-examined. No, they have re-examined. Re-examined. Re-examination in chief of Dr. Selamanti Jojo.
Jojo was not declared hostile.
Re-examined. But the other person was declared hostile. Only one line was asked.
So when the Dr. Jojo is concerned, you cannot cross-examine because you have not filed any application, you have not.
No, she herself stated, my lord.
She was not a hostile witness.
No, she was not a hostile witness. But she says that I prepared it and Dr. A.K. Sahu signed it. But my question, if your lordship looks at the evidence of doctor, he himself has stated that we have not expressed any opinion. The reason being.
Mr. Mishra, I am just time and again I am on that question that we have no disagreement. In the report, there is no cause of death. When you asked him, they admitted, no, we have not written anything about the cause of death in our report. And then they said the cause of death is the cardiac arrest in the trial for the first time. Right?
Exactly right.
So, as a defense counsel, if you are a defense counsel at that point of time, this dispassionate witness, they are the professionals, they are coming to the court to do their duties. So you ask them on the basis of what you are making the statement, it was the cardiac arrest. Can you show me any notes? Because you just go through the duties of the postmortem doctor. He has to keep his record. And this is the primary evidence.
Yes.
They prepared the report, we do not question it because they are dispassionate witness. But these are the primary evidence. But you have not asked them that on the basis of
question
that it was done by
the good sir. You do 5.
I have taken the brief from Mr. Pradhan. Question all the questions. The defense would ask you. I am putting all these questions to you. I think we should conclude now. So here for some minutes, Mr. Pradhan. Mr. Rodriguez, I think you will not say anything to you.
Thank you, sir. I'll submit it to you after Mr. Pradhan.
Again?
I'll supplement to some extent.
No, before that you submit. Mr. Pradhan will give the final reply. He is the attorney.
Rajras, please.
Well, here, if your lordship looks at page 110, first question, ballot.
Yes.
Page 110, first question, that re-examination as the lordship was suggesting.
No, that was of Jojo.
At the time of postmortem disease, I did not find any disease in the heart of the deceased. Question, do you think that the death was caused objectively by cardiac infection or by cardiac thrombosis? No, the death was caused by neither by cardiac infection nor by cardiac thrombosis. That is the answer of the doctor.
You will read this paragraph 6 also, page 109. I do not find presence of red blood mixed with the fluid in the first report. But when it's found in the first report, it has coming out to blood from the nostril and mouth and the blood. After some hours, the blood is out from the dead body, including nose and mouth. Red blood and according to the existing advisory history, you can say all studies are all studies is constituted the most common cause of natural death.
Sir, page 108, if you're still looking well.
No, 109. Question 6.
Here, 8 if your lordship looks at page 108, paragraph 5, 4-5 lines after Mallard. Very interesting. Absence of such injury rules out application of force. Reserve my opinion awaiting chemical examination report on this report to ascertain about poisoning or not. Police has not called for any further report from us after receipt of viscera report. On perusal of chemical examination report of the viscera, I do not find if it's a case of poisoning. So I do not find it's a case of poisoning. So also the chemical examination report of vomiting, etc. I do not find poisoning substance. Coming through going through the postmortem report and chemical examination report, I find the case of poisoning is ruled out. In my opinion, let's you kindly mark here. In my opinion, I find that after perusal of the postmortem report, the death was due to cardiology. How can you say, but after going through the postmortem report, he jumps to the conclusion of cardiology?
Cardiology is not the cause. Cardiology is the sense of
Cardiology means it's a cardiac. Thereafter, if you also there are instances of healthy young persons dying due to cardiacs. The death due to cardiacs is called cardiac death. No one can die within 1 hour. So he tried to describe what is cardiology and cardiac. Cardiology means heart related.
So only
He looks at the postmortem report, jumps to a conclusion it's a cardiac arrest. But
I'm more interested in the prosecution has not asked any question there.
It is by called by the defense himself.
It's his own admission, but it's a defense cross-examination. His own admission.
There is no other material.
He only looks at the postmortem report and says the cardiac arrest. Postmortem doesn't indicate anything. And Mr. Katakia has explained to your lordship when there is symptoms of in the nostril and mouth there is blood, it's a case of asphyxia. Medically also he has established it. It's a case of asphyxia.
Yes. But substance yet only one thing, there is no other material. Conclusion. Only seeing the
so therefore, the doctor's conclusion with regard to his opinion of cardiac arrest is absolutely incorrect.
No problem. There is no cross-examination there. It is absolutely without any basis. It was not even put a submission to the doctor.
So, but in view of this evidence, he's No, I mean defense. He's not. It's not a case of that. I put a question or individual. He himself stated it. He himself stated. I looked into the postmortem report.
He very intelligent human being. He says after looking at the postmortem report, clinical report, I say your case of cardiac arrest.
No, with due respect, with due respect, yes, lordship. If it were so,
no, but I'm making what he said. First, come to what he has said. The trial.
Previously, he has said that chemical examination report, viscera report, doesn't indicate poisoning.
And he gives an explanation also that why he could not write the opinion because the police, after receipt of this, did not reward it back.
Yes, but he in the court after 2 years he looks at the postmortem reports.
It's not that you have given a very intelligent explanation that I had given after the postmortem examination is done. We both give the report to the police officer with the requisition and sending the viscera to them for chemical examination. When the chemical examination report was received by the police, it was duty of the police to revert back this postmortem examination report to us to write our opinion, but the police has not done it.
And the court 2 years after they look at it and say that
after seeing, he did not put even a suggestion that how can you say that now it is a cardiac arrest? What is the material before you?
In fact, there is no material, man. In fact,
I try to understand. So to discredit someone's statement, you have to put some material. It is not automatic.
But
That is the idea, or that is the tool of the cross-examination suggestions are put. Then you are not stating the truth.
I just want your lordships to appreciate this sentence, my lord, one sentence. In my opinion, after perusal of the post-mortem report, the death was due to cardiology.
Cardiology, that we have pointed out.
Right. This is a one statement, if your lordship kindly see, my lord. I just want your lordship's appreciation on that, my lord.
Map is not. Plus, I want to draw your lordship's attention to page 110. The deposition of Schedule 5, where he has been re-examined loss. And all the questions, whatever has been put to him, have been objected. Yes, Schedule 5,
110.
page 110. Plus, first question was at the time of postmortem of deceased, I didn't find any disease in the heart of the deceased. Do you think that the death was caused objected by cardiac infection or by cardiac objected by cardiac infection or by cardiac thrombosis?
He says no.
Yes, yes, no. Then next question. Regarding sudden death, can you give a single instance that a lady of sound health at the age of 22 years has died of cardiac arrest in India, or have you come across such a case in your experience in medical science? Answer: I have come across few such cases. Cardiac lady of that age in India with sound heart, but I cannot give particular of those cases. Then important is the question, last but one, that is in a sleeping condition. In a sleeping condition, it has been objected by the defense. In a sleeping condition, by means of soft pillow or by soft clothing, someone's mouth and nostrils are gagged. Out of fate, she can get shock and he can die. Answer is, during the process of gagging, if she gets awakened, she may be frightened, and out of that sudden death may happen. This part may be noted loss. On the next page, loss is one. What?
Whether this is relating to the present case. It is generally describing
Opinion. Yes, plus.
Phenomenal statement.
Yes, I am coming to the page 111. Next page, plus. The question has been put by the defense. In the cross examination, the first paragraph.
8.
Yes, paragraph 8, and last 5 lines are the reading loss. If the mouth,
Yes.
if the mouth and nostril be gagged in soft pillow and she dies, that will be asphyxial death. And in that case, there will be congestion of lungs and deposit of water in lungs. That I had argued, I was arguing yesterday, loss. It is his opinion, it is that doctor's opinion. Then loss, in the present case, there was no congestion of lungs. He can't say because exit 4 has not been objected. Here again he is saying there is no congestion of lungs and there is no deposit of water. So asphyxia death is completely ruled out in this case. Because he knows that if there is congestion, that will lead to asphyxia. If again I am reading, if the mouth and nostril is gagged in soft pillow and she dies, that will be asphyxia death. And in that case, there will be congestion of lungs and deposit of water in lungs. What will happen? That is in exit 4, I have shown you last yesterday. In the present case, there is no congestion of lungs. That you can't say. Because exit 4 says that there is congestion of lungs. And because it is within his knowledge, my humble before lordship, that is, so asphyxia death is completely ruled out in this case. He is saying that because there is no congestion, so asphyxia death is ruled out. Because there is a congestion of lungs very well present in if your lordship has come across from exit 4. It is not that it has not been put to the doctor, because the doctor is helping the accused person. That is the reason why the public prosecutor must have felt so many troubles. That is the reason this question in that way he has got the answer. Because the doctor knows that if there is congestion of lungs, then this is a...
Tell me one thing. Whether law prohibits to bring in another specialist to examine the reports?
Should have been.
Doesn't prohibit laws.
Have you done that?
Doesn't prohibit. Even here also the Supreme Court can call under section 391 of CRPC. That question I am getting from the side from that side. Also here also the Supreme Court is empowered to call for a specialist on this issue.
391 application so much.
Yes, let me verify. But when it is clear, this is not required. My humble suggestion.
Because this is provides to the initial evidence at the stage of appeal.
Yes. Yes, yes.
So either the appellant or the defensive file an application before that what kind of evidence they want to give.
Yes.
If the court starts applying the power of 391 for evidence,
Yes.
court becomes the prosecutor.
Yes, please.
Yes, that's possible.
Yes, yes. Just a minute. Sorry. Appellate court may take further evidence or direct it to taken. In dealing with an appeal under this chapter, the appellate court, if it thinks additional evidence to be necessary, shall record its reasons and may either take such evidence itself or direct it to be taken by a magistrate, or when the appellate court is a high court, by a court of session or a magistrate. When the additional evidence is taken by the court of sessions or the magistrate, it or he shall certify such evidence to the appellate court, and such court shall thereafter proceed to disposal of the appeal.
That is the procedure.
Yes.
That's the procedure.
Plus, there are enough evidence here in this case to show that this is a case of asphyxia. Because here this question itself, whatever has been put in the cross by the defense itself suggests that he knows that this is a case of asphyxia, but he is denying. He is saying that no, it is a case of cardiac arrest. Likewise, loss. I'll take a lawsuit to the deposition of period 19, page 153. One by two. Of course, plus he is saying that dried blood mixed were present on both nostril and mouth. 153. Period 19 starts from 153. There was, she has categorically stated, was on examination found as follows: Roman I. Plus, there the second line, dried blood mixed were present on both nostril. So 153 plus. Yes. Yes. That is plus Roman I. Second line, dried blood mixed were present on both nostril and mouth. That analogy I have explained yesterday, so I am not repeating it. Then paragraph 3, thorax, cavity and lungs and heart were intact, normal and congested. Plus I am taking also to the relevant paragraph, paragraph 5, page 156.
On re-examination.
Yes, boss. Second question regarding sudden death. Can you give a single instance that lady of sound health at the age of 22 years has died of cardiac arrest in India? Or have you come across same question, similar question put to that doctor? I have never come across of a person having young age died due to cardiac arrest. Then plus 157. Next page plus. If mouth and nostril of a person is gagged by means of soft pillow, whether he can die out of frightened after awakening, getting shocked. She said yes. Then also come to the cross examination. I'm reading paragraph 6. I am a specialist in pathology. I'm reading the whole paragraph clause. Many things will come out. I have just completed 5 years of service in district headquarters hospital, Jharsuguda. There are many medicine specialists in the district headquarters hospital who attended the cardiac patient. In normal course, we didn't deal cardiac patient. In emergency case, we requisitioned the medicine specialist. I have no experience of treating the cardiac patient. Dr. A.K. Das, P.Role 5, is the senior most medicine specialist of the district headquarters hospital, Jharsuguda. Cardiac arrest may be possible without the cardiac thrombosis and cardiac inflection even in healthy young person. Sleeping pills can be detected in the viscera in chemical examination. If mouth is important, I am putting more emphasis here. If mouth and nostril are gagged, that will be death due to asphyxia. This is then says this is not death due to asphyxia. In the present case, death of the deceased due to cardiac arrest and mode of death synco. In case of gagging of mouth or nostril, lungs here must see the exact things what is required. In case of gagging of mouth and nostril, lungs may spongy and secretion may be deposited in lungs. In the present case, there is no deposit secretion of lungs, nor it is consistent. Again, contradiction. So probably she has not remembered whatever has been written in the exhibit 4, which has not been objected by the defense. Those serious objections have been put everywhere while being re-examined, both the witnesses, P.Role 5 and P.Role 9. But no objection has been raised at any point of time, so far as exhibit 4 is concerned. So that remains consistent. So the second part has to be ignored. That what says that there is no deposit secretion of lungs, nor it is consistent, that has to be ignored. In view of exhibit 4, existence of exhibit 4. And she also knows that, so asphyxia is completely ruled out in this case. And because there is no congestion, so asphyxia is completely ruled out. So she knows that if there is congestion, asphyxia, it will be asphyxial death. So a conjoint reading of the deposition of both witness P.Role 5 and P.Role 19, along with exhibit 4, there is the post-mortem report. It is a clean case of asphyxial death. I have explained in last yesterday. I don't want to take more of the last time. And one aspect I am just bringing to last time of this. Here it is a case of unnatural death because UD case has been registered, as has been stated by the IO P.Role 21. We are going to start from page 163. Just I am taking last few minutes. 163, paragraph 3. Paragraph 3, prior to the lodging of affair, on the same day of the occurrence at 9:30 a.m. morning, on the written report of Bimal Kumar Khetan, son of Kailash Kumar Khetan of Post Office Lane, Jharsuguda, I registered UD case, that means unnatural death case number 28 dated 1/10/2005 and took up inquiry. It has never been objected, because in the 313 statement, as Malay has already read out, at para 90, he has admitted that I have given a report and that has been registered as a UD case. That is, will also get from page 89, question number 20. So UD case means unnatural death. From the beginning, it is unnatural death. It has been registered as unnatural death. And what made the accused to remain silent, not to come into the witness box to explain all those things? Plus, I am saying this. Because he is taking a plea, and you will also find none of the witnesses examined has been suggested that is a case of cardiac arrest. None of the witnesses. No suggestion has been given whether this is not a case of.
No, we like to understand what is the proposition you are now trying to build up.
Plus, I am just, my point for Lordship is that he is facing a charge of murder loss. Yes. Should I read the charge loss?
No, you should not read.
Yes.
Your question that Article 20 is there.
Yes, Lord. Yes.
You cannot force something. In 106 of the evidence said, you cannot force.
Plus, if a death has occurred,
you have to take a decision.
Yes.
When there is a case of circumstantial evidence, that whether the circumstances have been taken that level that only he can do that or nobody can do it.
Yes.
Then only his oral responsibility can come to the court and one there is
Yes.
explain certain circumstances.
Yes.
Otherwise, he doesn't have because right to silence in our criminal jurisprudence is well.
No, that is not. Yes, my humble is what I
You can question where he can come. You can show that this is the things prosecution has made of the case that only he is the person who knew what happened, but he has not come to explain it.
Yes, because the occurrence has taken place within the four corners of the house.
Yes.
And it is very well evident from the evidence, entire evidence, that that person is present in the house. In the bedroom, because all of them have, all witnesses have found the dead body in the bedroom, lying in the bedroom.
He has also stated.
Yes, he has stated. So he was present there in the house. So he knows it is within his special knowledge as per 106.
What he has said, whether court will believe him or not believe him is a different issue. He was not a totally silent.
Yes,
he said in the morning I tried to wake up my wife and she was not waking up, and then I called the doctor.
Yes. Plus, why I am subject to lordship's appreciation, I am trying to apply section 114 of the Evidence Act.
Presumption.
Presumption in respect of what?
Yes. 114
Special numbers.
Special number 14
Special knowledge is 106.
Yes, special knowledge 106. But 114 law says, court may presume existence of certain facts. Just for lordship's appreciation, I am reading that. That court may presume the existence of any fact which it thinks likely to have happened regarding her to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. The court may presume illustrations plus G I am coming.
Yes.
That evidence which could be and not produced would be, if produced, be unfavorable to the person who withholds it. As because the UD case has been registered, he has taken the plea that I have filed a report before the police, which has been ultimately registered as a UD case, that he didn't like to come, bring the notice of the court. And that's the reason in that way he has withheld that evidence.
No.
My point is that was.
How do you say that?
Article 23.
No. How do you say that? This is his abnormal behavior, normal course, the people will not go to file it. He reported to my wife.
Yes.
Right? And this police registered it in the UD case.
UD case.
So he has not decided that is an unnatural death.
No, because the case has been registered UD case and he has not objected to that.
This is not evidence for unnatural.
There is no evidence. That will also not come up plus.
Yes.
And also far as deposition period 6 is concerned, Governor Nagral, who happens to the father of the deceased, plus in the FR he has stated everything else. And but while being examined by period from the evidence of period 21, just I am taking lordship to that part only. Because period 8 is consistent as I have submitted yesterday. Because Governor Nagral, it is at page 175, paragraph 30. I'm just reading for a moment. It's paragraph 30. In this case, prosecution case of demand for dowry is only after marriage, that is 3 to 4 days after the marriage. It is a fact that Period 6 Governor Nagral has not stated before me either in the FIR rules. You will also see the FIR, the entire things have been stated in the FIR. And a person who is writing, who is stating everything in the FIR, can you expect that he will not disclose it before the police? For some reason or other, it has been given a call. Of course, many things plus I can't.
Whether his statement was recorded under section 161?
Yes.
Yes.
His 161 statement must be there on record.
Yes. Record. And but FIR he has stated.
This is the very fundamental things. Yes. If you find in the 161 statement he has stated or FIR he has stated, immediately show the witness.
FIR there, boss.
We have not shown the FIR when such statement is made to the witness. Confront him.
Yes.
That's all I think. We have covered entire spectrum of the issues that
You can give a short note with bullet points only.
Bullet points only. Side, yes, bullet points.
The entire case is what my learned friend was trying to convince the lordships. It is a case of asphyxia. Asphyxia due to suffocation. Though my lord, he has not used the word suffocation, but he's relying the chapter Modi's jurisprudence. His case is that if a person dies on account of suffocation, asphyxia will cause. So let's see, kindly see the document he has supplied. So what would be the appearance due to asphyxia that has been indicated? My learned friend, I don't know whether he knowingly avoided that or not, I don't know. The dried blood and blood truth, my lord knows. Entire case is dried blood coming out from mouth and nostril. But in case of asphyxia, blood truth will come, not dried blood will come. You'll also kindly see what would be the external appearance, and injury also will come from the face. You'll also can see appearance due to asphyxia. Document has supplied, my friend has supplied that. But appearance due to asphyxia, in respect of suffocation is concerned, the face may be pale or suffused. It is not there in the PM report. The eyes are open. The eyeballs are prominent and conjunctivated and congested, and sometimes there are petechial hemorrhage. There is also nothing in the postmortem report. You also will find from the PM report, doctor has specifically said both the eyes and mouth are half open, but in respect of asphyxia, the facial appearance and the external appearance will come. It will be open, fully open, and lips are livid, and tongue sometimes protruded. Bloody fluid comes out of the mouth and nostril. The skin shows punctiform ecchymosis with lividity of the limbs. A rupture of tympanum may occur from a violent effort at respiration. Not a single external appearance found place in the PM report, or none of the prosecution witness have whispered about anything of the region of asphyxia. Now, internal appearance also will kindly see. My learned friend is giving importance on the lungs. Lungs has to be congested. No, everything has to be congested in internal appearance in case of asphyxia. Brain, liver, spleen, everything will be congested. That in the internal appearance, my lord, kindly see that will move the jurisprudence. My friend referred that. Rats, mold, or any other foreign matters may be found in the mouth, throat, larynx, trachea, when suffocation has been caused by infection of a foreign substance in air passages. It may also be found in pharynx or esophagus. The mucous membrane of the trachea is usually bright red and covered with bloody fluid. Nothing is there and congested. The lungs are congested and imphosomatous. That imphosomatous will be enlarged. Imphosomatous it will be enlarged. Nothing is there. It may be lacerated or contused even without any fracture of the rib if death has been caused by pressure on the chest. Punctiform and subsurial ecchymosis are usually present at the root, base, and lower margins of the lungs. It is not there. But there are not characteristics of death-based suffocation, as they may be also be present in asphyxia death from other causes. They are also found on the thighs and pericardium and along the roots of the coronary vessels. The lung may be found quite normal if death has occurred rapidly.
My learned friend says his lungs will be congested. The Modi says lungs may be found quite normal. That has been indicated in the team report. If death has occurred rapidly, it has happened in the rapidly death has been occurred. The right side of the heart is open, full, and dark pure blood. It is not there. And left empty. The blood does brain is generally congested. Brain are not congested in the present case. And so are the abdominal organs, especially liver, spleen, and kidney. Everything will be congested. Where is the question of death of aspasia? If external appearance, internal appearance, nothing suggested. This is Modi said, my friend is only one aspect is referring that lungs will be congested. Only one aspect. Yeah. But everything will be congested as per the Modi. This is so far as aspasia is concerned, suffocation is concerned. Now, I am referring that Harrison. The Harrison said, without any infection in the heart, a lady can die in the house. It is happened in case of women, mostly in house and in the morning hour also. It is happened in my case. If Harrison chapter 299, my lord, I will give a better copy because the last second I have given it is not vigil. But here Harrison specifically corroborates the PM findings given by the P5 and 19. In respect of lady, it will happen in the early morning and there will be no infection. Arrhythmia, that means irregular in the heart. At any moment, anything may happen. If irregular will come in the heart, a person, a sound health, a man or woman, can die within 1 hour. That is Harrison.
But there is no documents relating to the pre-history of the cardiac status.
Mala?
This irregularity that you are talking about.
No, there will be no irregularity. If a sound health person, without having any history of cardiac problem, die at any moment within 1 hour, it's arrhythmia will come. Mala?
Why is that history?
No, history is not required. That is not
That is not the meaning of this statement. If someone is this suffering from certain irregularity, that is the heart movement irregularity also, that sometimes it can happen.
Yes, it is there. It is there. It will happen. That cardiovascular collapse at any time, any person, anywhere may occur, and within 1 hour can die. That is the Harrison says.
All right, that's all.
I'm grateful for the patient hearing, in fact. That too over time. Okay.